We are on the record in case number 2022-00387, electronic tariff filing of Kentucky Power Company for approval of a special contract with Ebon International LLC. My name is Kent Chandler. I'll be presiding over the hearing today. Joining me is Vice Chair Angie Hatton and Commissioner Mary Pat Regan. I'd ask those in the hearing room to please turn off or silence your cell phones. And I'd ask those that are participating remotely to do the following. Please mute your microphone when you are not, and turn off your video when you are not speaking. If you use a phone for audio and a computer for video, I'd ask that you turn off your computer audio. And I'd finally ask if you have issues participating today or experience technical difficulties that prevent you from participating, that you please contact either your representatives in the room or directly contact the commission through the staff attorneys. The attorneys for commission staff should have previously provided contact information to do that. The purpose of today's hearing is to take evidence in this matter. Before we get started, we'll have an entry of appearance of counsel for the applicant, Kentucky Power.
Good morning, Katie Glass of Stites and Harbison for Kentucky Power Company. Also appearing with me is Hector Garcia Santana. He's appearing pro hoc vice. That motion is still pending.
And we'll take that in just a minute. Thank you, Ms. Glass. And for the Office of the Attorney General,
Mike West, Office Attorney General.
Mr. West. And for the intervener, first we'll go for the Kentucky Industrial Utility customer.
Morning, Your Honors. Mike Kurtz for KIUC.
And for, I guess we'll call them the joint interveners.
Morning, Commissioner Byron Gary, on behalf of the joint interveners, appearing with me, Thomas Samar and Schema Lochan, appearing pro hac vice.
Thank you. And for commission staff.
Good morning, Your Honor. Justin Young and Jason Collier.
Thank you. So Ms. Glass will first take up, I believe you all filed a motion yesterday, the day before, at time, doesn't matter anymore, but recently indicating a request for deviation from the notice requirements because one of the notices did not run correct. Is that right?
That's correct. We did request the notice to run over the last couple weeks, but the paper is a small paper. Their publisher passed away and they were unable to run it. We were informed that it did run on Tuesday, so notice has been provided, but not within the window that's required.
The 7-day window.
Correct.
That'd be fine. So we'll formally enter an order, but it won't keep us from having a hearing today.
Thank you.
Approving that motion. And we have reviewed Mr. Garcia Santana's motion for leave to be admitted pro hoc vice. And I guess I'll informally approve that today to allow Mr. Garcia Santana to participate, and then we'll enter a formal order doing so after the hearing.
Thank you very much.
Thank you, Your Honor.
All right. We required by order for Kentucky Power to provide notice of this hearing, as was discussed a minute ago. The notice for the hearing, public notice, indicated that any non-party could provide public comments before the hearing or at the hearing, immediately before the hearing, either remotely or in person. No one has indicated their interest through the option on our website, which the notice provided instructions on how to do that. No one has indicated their interest in providing remote or virtual comments. And as of earlier this morning, no non-party had come to provide comments. So I will open it up for anybody in the room. If there's any non-party that would like to provide public comments on this case, I'd ask that you come to the microphone and indicate your interest in doing so, and that prior to providing public comments, that you provide your name and your address.
Good morning. I'm Chris Pullum. I'm the Community and Economic Development Director for the City of Ashland, Kentucky, 1700 Greenup Avenue, Ashland, Kentucky, 41101. I'm here as an interested party. We have a project that has been represented through the Kentucky Cabinet for Economic Development for our community that is roughly, it's not roughly, it is representing 1,000 jobs, a $300 million investment that we believe is dependent upon the decisions made by this panel today. So That's who I am, that's why I'm here, and we are in support. Thank you.
All right, thank you. Is there anybody else that'd like to provide public comments? Okay. I would just let anybody that is either watching live or reviewing this hearing prior to the submission of this case, that you can provide public comments at any time, one of three ways. You can either mail them to the Public Service Commission at 211 Sauer Boulevard, it's Sower, Frankfort, Kentucky 40602. You can email them to the Public Service Commission at psc.comment@ky.gov. And you can also enter them through our website, which is psc.ky.gov. I would ask that anybody that provides public comments in this case, that you indicate your name, your address, and the case number. Just a reminder that the case number is 2022-00387. All right, seeing no one else wanting to provide public comments, are there any other issues or motions or petitions that we need to take up prior to cross-examination?
Your Honor, we do have 4 motions for confidential treatment that are still pending, but that's it.
Okay, all right, thank you.
Thank you.
And I will leave it up to the individual party. Oh, I do want to ensure. I know that the, I'll get this right here. I know Ms. Sherwood has likely signed an NDA given the basis of her testimony. Ms. Holding is also subject to the NDA or a confidential agreement, in this case for the confidential information pending the filings, is that right?
Yes, Your Honor.
Okay, and the same for Mr. Barron?
Yes.
Okay, and are you aware of any of the counsel that Mr. Gary brought up this morning that are not subject to that confidentiality agreement?
Not that I'm aware of at this time, but I can double check. I believe
I just want to make
that's
sure
correct.
that we can just go on to the confidential session as a matter of course, instead of having to stop and ask each person, are you under the confidentiality agreement, and ask everybody to leave the room. I just want to make sure that we're clear about who that needs to be up front. So,
Yes. I believe that's correct. Mr. Gary, are you aware of whether there's anyone who hasn't signed the NDA? I don't think there is.
Yeah, I think we've all signed it.
Thank you very much. We're
okay.
good.
So, I'll just depend on you all then to indicate anybody in the room that's with the company or with the agreement that would need to not be here necessarily, because I think everybody else, Mr. Putnam aside, is either with the commission or a witness or attorneys for the intervening parties.
Okay.
Right.
And Your Honor, I'd also like to point out there is some pricing information in this case that is confidential and attorney's eyes only.
Okay.
That it's specifically with respect to just the pricing information, so that's subject to some special terms within the non-disclosure agreement.
Okay. All right, and do we have a copy of that non-disclosure agreement?
Yes, I did file them into the record.
Okay, that'd be great. Thank you very much.
Thank you.
All right, Ms. Glass, would you like to call your first witness?
Yes, Kentucky Power Company calls Brian West.
All right, Mr. West, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat, state your name and business address for the record.
My name is Brian West. I'm the Vice President of Regulatory and Finance for Kentucky Power. My business address is 1645 Winchester Avenue, Ashland, Kentucky 41101.
All right, Ms. Glass, you may ask.
Thank you. Mr. West, did you cause to be filed into the record of this case testimony and responses to data requests?
I did.
Do you have any changes or modifications to that testimony or those responses?
I do not.
And if I were to ask you those same questions today, would your answers be the same?
They would.
The witness is available for cross-examination.
Don't think we discussed it, but just as a matter of course, we'll go with Mr. West first. Mr. Smar, and then we'll,
Chairman, we were going to go KIUC, then the Attorney General, then joint interveners, if it's okay with you.
I don't care. So that's fine. Whatever. However you all like to do, I just ask that it be consistent across the different witnesses. So we'll go Mr. Kurtz, then Mr. West. Is that what you all discussed, and then Mr. Small? That'll be fine. Mr. Kurtz?
Thank you, Your Honor. Mr. West, you have a copy of the contract attached to your direct testimony. Will you turn to page 1, please?
Yes, I do. If you'll give me just a second. Okay.
The contract is with Ebon International LLC, a Delaware limited liability company. Is that correct?
Yes.
Do you know who the owner of this LLC is?
It's my understanding that the parent company is named eBang.
Do you have any kind of parental guarantee to guarantee the obligations of the LLC?
I'm not aware that we have any parental guarantee like that, but the contract itself has significant conditions in it that will sufficiently protect the company and all other customers.
Well, you understand if there's a dispute, a lawsuit between Kentucky Power and the LLC, you're limited to the LLC. You can't go after the parent company. Do you understand that?
Objection
Well,
to the extent it calls for a legal conclusion.
Okay. Sorry, it's still very early for the first objection, Ms. Collins. Sustain the objection. Subject to, are you content not providing a legal opinion given that you're a layperson? Not that, I always hate that, I'm sorry. Mr. West, you're not a layperson, you're just not an attorney.
I'm not an
You're a mere
attorney, sir.
mortal, yeah,
Yes.
no. Okay, subject to the concern around you providing a legal opinion, please answer the question.
Well, Mr. Kurtz, I'm not an attorney, so I really can't speak to that.
Okay, you don't have a letter of credit, a guarantee, any type of security behind the limited liability company?
You mean from the parent?
Well, the letter of credit could be from anybody if you had that. In other words, if there was a dispute between Kentucky Power and the limited liability company, how, over this 10-year contract, how would you be certain that they wouldn't bankrupt the LLC, that there's any assets behind the LLC? How would you be certain that you could collect anything? You could sue anybody, but how are you going to collect?
Well, this is no different than any other customer, Mr. Kurtz. This could be any large industrial customer, and we have, intentions to collect the appropriate deposit that is 2/12 of the bill, not including the discount, so it's a full tariffed rate. We have, opportunities under the law, it's my understanding from our counsel, that protect the company in those circumstances. And as I said, this is no different. We cannot discriminate unreasonably against this customer because of their business model or their parent.
There's nothing requiring you to give such a discounted economic development rate, is there? You're not required to do that.
We're not required to do that, but should the customer take service at full tariff rates, that would cause greater costs passed on to other customers. This is the best solution for this customer. This customer, if you'll let me finish, Mr. Kurtz, this customer is a perfect match for this service territory. It's a perfect match for the location at the Big Sandy plant. Their operations are well-suited for that site. They are going to invest significant dollars in permanent infrastructure at this location. And as I said, we cannot unreasonably discriminate against this customer in favor of other customers. The contract itself has, it's based on tariffs IGS, modeled after discounts in tariff EDR, and it requires the customer under Rider DRS to interrupt, and that's a peak shaving product. It has other conditions in it that are designed, and I'm speaking of the floor price, that are designed to ensure that the customer is covering marginal costs, covering their fuel costs. There are numerous protections in this contract, sir.
Chairman, can I have the question and answer reread, or at least just the question? Because I don't know that was responsive to anything. It was so long, maybe it was.
I don't think, there's no question and answer, there's no question reread. The audio is the official record, we don't take it as verbatim.
Okay, could you instruct the witness to at least answer the question directly?
Would you like to ask the question again?
I forget what the question was, the answer was so long, but I'll move on. So, the 2/12, that just covers you if they default on a bill payment. You use electricity in July and get a bill in mid-August at 15 days to pay. If they don't pay, you're out 2 months worth of power. That's the standard deposit in the commission's regulation and your tariffs that every customer pays. That's no.
That's correct.
Okay, so let me go back. This is a limited liability company. You don't really know who owns it or what kind of assets are behind it. And you think you're protected under this 10-year contract without any security or parental guarantee?
I think based on the fact that this customer is still here, 2 years after the fact that we started discussing this project with them, speaks volumes to that. And the fact that they're investing significant millions of dollars in permanent infrastructure at the location.
Okay. Your Honor, can I have marked as, I guess, KIUC Exhibit 1?
Thank you.
Are you familiar with?
So marked.
Yes. Are you familiar with the Commission's decision in Order 327 regarding economic development rates?
I have read it, yes, but this contract was not filed under our tariff EDR.
I understand that. We turn to the second page of the KIUC Exhibit 1. Let me read you what's highlighted. Economic development rates should only be offered during periods of excess capacity. Utilities should demonstrate upon submission of each EDR contract. This is a contract, right?
Yes.
Okay. That the load expected to be served during each year of the contract period will not cause them to fall below a reserve margin that is considered essential for system reliability. Such a reserve margin should be identified and justified with each contract filing. Do you think Kentucky Power meets that requirement?
I do.
Okay, we turn to the third page of this exhibit, which is from your recently filed Integrated Resource Plan. Doesn't this show that Kentucky Power will be 115 megawatts short in 2026?
I would like to point out that resource planning is not done for a specific customer. It's done for the entire company. It's a complicated process. We currently have and participate with the other AEP operating companies in the east. In PJM, we have a compliant FRR plan on file with them. We have sufficient capacity to serve our customers.
Okay, you didn't answer
I'm
my
sorry,
question.
yeah. That's the second time this morning, Mr. West. It was a very straightforward yes or no question, I believe. And I get that you want to explain your response, but you did not answer that question. Will you please answer the question?
Can you repeat the question, Mr.
I believe the
Curtis?
question was, are you capacity short in 2026?
Currently, that is what it shows, and we are working on our plan as we speak.
And when the Mitchell entitlement ends in 2028, you'll be 713 megawatts short. Isn't that correct?
If that's what it says, yes.
And you have about 1,000 megawatt load,
Roughly, yes.
and this is a 250 megawatt contract.
That is their full load, but as they participate in Rider DRS, we're only required to have sufficient capacity for their firm service level of 25 megawatts, which is a tremendous benefit to the customers of Kentucky Power.
We'll get into this, but that assumes that you interrupt them during the 5 PJM PLC hours every 5 times every year of the 10-year contract. You hit that mark precisely, because if you don't, isn't it true that you'll be required by PJM to get more capacity than just the 25 megawatts of firm plus reserve margin?
It's true that that's a possibility, but the fact is that we've never missed one of the 5 CPs. And other customers that we have on Rider DRS have faithfully dropped load when we've asked them to. And that's what the record shows.
Let me ask you about energy. It's true, isn't it, that at the 250 megawatt full phase 2, that this customer will use about 2 billion kilowatt hours a year?
I haven't done the math on that, but that could be correct.
Let me ask that this be marked as KIUC number 2.
So Mark,
Let me back up. And Kentucky Power's current native load is about 5.4 million megawatt hours a year.
This is the first time I'm seeing this document, so
This is an S&P Global right off of your Form 1, but I'll just ask it generally. Isn't it true that your native load is about 5.4 million kilowatt hours a year?
that sounds about right.
Okay. So when you add 2 billion, let me show you where the 2 billion comes from. This was page 3 of this exhibit. This was attached to your testimony. It's the marginal cost study. You see at the top where you have the kilowatt hours?
I do.
It's about 2 billion.
I see that.
Okay. So this customer would add about 37% to the energy requirements of the existing system.
That's true, but they're also paying tariffed rates for that energy. No different than any other customer.
Well, they are different because they're getting a huge discount on the demand charge, aren't they?
They're getting a discount on the demand, but not on the energy.
That's a problem, actually, isn't it? Because where are you going to get the energy? You don't have enough energy to serve your existing customers. Where are you going to get the energy to serve the LLC?
We currently purchase energy from PJM. I think that you well know that, our generation is sold into the market and then we buy back the energy that we need to serve our customers. That's how it works. We would do that for any other customer. We do for all of our customers. So this is no different.
You keep saying that, but this customer is completely different. They're getting a huge discount. Everybody else is paying full tariff rate, isn't that true? So they pay you full demand charge and they get your average cost energy.
I wouldn't say that every other customer. We have other customers that are on tariff EDR contracts. We have some that are on special contracts. So there are some that are adhering to the terms of whatever those contracts are.
But the vast majority of your customers are paying your full demand charge, and they're entitled to the average energy cost on the system. Isn't that right?
That is correct, but the whole point of offering discounts to a customer like this is to, for the economic development benefits that they bring to the region.
Well, if everybody else's power bill goes up, have you factored that into whether this is economic development or economic undevelopment?
This is economic development. There's $96 million that is going to go into the community in Lawrence County in year one, and about 26 or 27 million annually thereafter. Those figures were not factored into, I don't believe factored into the calculations from Mr. Barron or the witnesses from the joint interveners, but they are there and they are real.
You're quoting Ms. Clark. We'll get to her later, aren't you?
Company witness Clark has more details on that, yes, sir.
Now, if you have to purchase power from PJM to serve this 2 billion kilowatt hour annual load, those purchases will run through the fuel adjustment clause, won't they?
Yes, and this customer will pay full tariff rates for their energy.
And everybody else will pay higher fuel adjustment charges to cover their load, won't they?
It would be no different than any other large customer that wants to locate in this service territory, and we offer them a special contract.
Well, except that this customer is getting a huge discount. That's what does make them different.
What they're getting is something that's modeled after an approved tariff on Kentucky Power's books, modeled after tariff EDR. And you refer to it as a huge discount, but it is the discount that is in our tariff.
Well, plus the incremental discount. But you're aware that last year, the fuel adjustment caused grave hardship to people because your purchases were so big at such a high price, everybody had to pay a higher fuel adjustment.
And I believe that the current prices show that 2022 was an anomalous year.
This contract is a 10-year contract starting when they go commercial. This could run until the mid-2030s.
It could, yes.
So nobody knows what energy prices are going to be at that point, do you?
I was just getting ready to say the same thing. Nobody knows what those prices are going to be. But how could you do anything if you sat and said, gee, we don't know what those prices are going to be, we have to turn everything down?
Why did Kentucky Power, why didn't this load go to KU or Appalachian Power or anybody? How did Kentucky Power end up with this when you don't have enough power for your own customers?
I believe the customer, sought out locations in Kentucky, based on the General Assembly passing certain legislation that offered incentives for projects that are like EBON, which is a blockchain company, to locate in Kentucky. It's very clear that the governor and the General Assembly have incented this and have spoken about this as economic development for the state of Kentucky.
Let me ask you to go to page 4 of this exhibit. Again, this is S&P Global right off of your Form 1. The generation from your half of Mitchell over the last 5 years has been 2.242 million megawatt hours or billion kilowatt hours. Can you accept that based on S&P Global?
I didn't do the math on it, but I'll accept that subject to check.
Okay. Now, Mitchell's going to be over at the end of 2028, right?
That's correct.
Okay. At that point, all you'll have is the 260 megawatt Big Sandy gas plant for the entire system.
That's true, but as I said, you know, the IRP is currently in front of this commission. I'm really not prepared to answer, you know, in-depth questions about that today. I didn't actually do the modeling of it, but I'm involved in working on securing additional resources for the company.
Mr. West, just for ease of reference, I've put together an exhibit number 3, which is your testimony and some of your data responses. Just mark the case, 3. So marked. Okay. Let's go to, this is, the first
Can I
page.
just clarify, Mr. Curtis? The highlighting is yours and not the indicated confidential portion. Doesn't have any confidential information in it.
Correct, the next exhibit does.
Okay.
Okay, page 2 of this is the contract. You see that at the top? The contract says the customer plans to invest $50 million at the facility and create at least 50 to 100 new permanent full-time jobs. Is that correct?
That's what it says, but I do recall clarifying that in a discovery response, saying that that was an initial estimate, and the numbers that I quoted, I think 85 million in fixed assets and $250 million total investment, were revised afterwards.
Okay, and then on page 3 of this exhibit is your direct testimony saying that they're going to invest over 250 million. So how did it go from 50 to 250? How did it go 5 times bigger?
I think that witness Clark may be able to answer that more appropriately, sir.
Okay. Page 4 of the exhibit is, at the top it does say, Your Honor, highly confidential, but it was just the bottom question which I took out.
That's correct.
Okay, so page 10 of your direct testimony says, the highly technical nature of Ebon's operations will necessitate hiring and maintaining approximately 100 positions. I'm going to skip to the yellow. The majority of these positions are for the most part very technical professional positions ranging in annual compensation from approximately $44,000 to approximately $76,000. Did I read that correctly?
Yes, sir.
Okay. And then you go on to say that the median household income in Louisa is $29,167. Is that correct?
That's correct.
Okay. Let's go to the next page, page 5. This was provided to the Attorney General in discovery. Or no, it was provided to joint interveners, actually. You see this?
Yes.
Okay. By phase 2, the Kentucky Power is estimating 115 employees, correct?
Where were you getting that?
At the bottom, at the
Oh, okay, okay. I see that.
115 employees at a total payroll of $5.3 million?
Yes.
Okay. Now, you said that the majority of these positions are, for the most part, very technical, professional, ranging from $44,000 to $76,000. Do you see the positions I have highlighted? Facilities technician, general maintenance worker, security guard?
Yes.
Okay. By my count, this is
That's 91 of the 115 new positions. Is that correct?
Where are you getting 91 at?
In phase one, we'll have 5 facilities technicians earning $37,518, 30 general maintenance workers earning $37,518, which is $18 an hour, 4 security guards earning $29,000, and then in phase two, you'll add 5 more facilities technicians, 45 more general maintenance workers, and 2 more security guards. That's a total of 91 positions.
Subject to check.
So by my count, 79% of the new jobs will earn $18 an hour or less.
These are still significant jobs for this location.
$18 an hour?
I haven't done the math on that, sir. I tend not to do that on the witness stand.
Well, it'd be 37,518 divided by 52 divided by 40, $18 an hour.
As you say, subject to check.
So when you say the majority are highly technical, highly paid, that's not true.
I wouldn't say that, Mr. Kurtz.
Well, 79% of the new jobs are going to earn $18 an hour or less.
Company witness Clark is the better witness to answer this question.
Let's talk about the capital you're talking about. And this was answered by you, page 6. So you were asked to, by the Attorney General, KEC, to break down the $250 million of CapEx.
Yes.
Okay. The vast majority of it, $165 million, you say is attributed to computing equipment that will be delivered, installed, integrated, and ultimately interconnected to Kentucky Power's substation, correct?
Yes.
Okay. Those computers are not manufactured in the 20-county area served by Kentucky Power, are they?
Not to my knowledge, no.
Where are they manufactured?
I don't know.
Are they coming from the parent company in China?
As I said, I don't know.
Okay. Would you agree that that provides, that the economic development benefit of the $165 million worth of computers derives from wherever they were manufactured, not where they're delivered to Kentucky Power? Or is that better for Ms. Clark?
Well, it is better for Ms. Clark, but I would say that this company is going to invest $85 million in permanent assets. And they're going to interconnect these computers, regardless of where they're made at. Once they're here and those jobs are in the communities, there's your economic development benefits.
Well, the computers can come and go. I mean, they're portable. They can be taken away. Isn't that true?
It's possible, but they're not going to invest $85 million in permanent assets so that they can plug them in today and unplug them tomorrow.
Okay, let's talk about the $85 million. What comprises that? Are you familiar in this record, the 250 containers that will house the computers?
I think that number is correct.
Okay, where are those where are those 250 containers to house the computers? They will not be manufactured in your 20-county service territory, will they?
Not to my knowledge, no, but once they're here, as I said, they will provide the economic development benefits.
Let me ask you a question about economic development. I know you're not the expert on that, but if you're familiar with Toyota Georgetown, obviously?
Yes.
Okay. They manufacture cars, and there's suppliers, and there's employees, and so forth. Mm-hmm. If they sell 10 cars to a fleet in Portland, where is the economic development benefit? In Portland or in Georgetown, Kentucky?
Witness Clark could answer that question, sir.
You don't really even have an answer?
Well,
wouldn't the economic development benefit be where they're manufactured, not where they're purchased?
Off the top of my head, that sounds right, but once those cars get to where they're going, in a fleet, as you mentioned, a company fleet, then those cars are used for the benefit of that community that they're in. So I don't think I would ignore where the vehicles are going, and in this case, where the computers are going.
Okay. You're not familiar with how the in-plan, input-output model works? That's Ms. Clark?
That is for Ms. Clark, yes.
Do you know anything else about the 85 million besides the 250 containers? What is this going to be? It's going to be a big metal building, I assume, to house this facility, correct?
No, we provided a map, I think, in staff 1 or 1-1 or 1-2 that shows a layout of the containers. They're not in a building. They're open. But I believe the first part of that response, Part A, says that in general, the investments are for engineering services, construction of the customer-owned substation, site preparation and container placement, container cooling system, and distribution network build-out for the containers.
Thank you. So, container placement, okay, that's the 250 containers?
That's what it's referring to, the container placement, yes.
That's helpful, thank you. Your Honor, I do have another exhibit that I would like to have marked, but it is confidential. KIUC 4.
Go ahead and pass it out to the relevant counsel, and then
We'll take up your request to go into the confidential records, so you can ask about it. So marked as KIUC Exhibit 4. Mr. Kurtz, just to be clear, before you ask to move on, is this a merely confidential or a attorney's eyes only?
I think it's part of it. I think it's attorney's eyes, I think.
It looks to be created by not
Yeah,
Kentucky
it-
Power, but it looks like it has information that is attorney's eyes only.
Yes,
Page 4,
page
for
4 and 5.
So, would you like to go on the confidential record to be able to ask questions about this,
Yes.
Mr. Kurtz?
Yes.
Okay. All right, we will go on to the confidential record. We're back on the public record in 2022-00387. Mr. Kurtz, you'd like to continue your cross-examination?
Yeah, thank you. Just very quickly, Mr. Rose, did you consider just the direct assignment of all the 2 billion kilowatt hours of purchases that you're going to have to make from the PJM market, just directly assign that to the customer, to Evon?
No, we wouldn't do that to any other special contract customer. Never have done that.
Well, but this is a, but by running those purchases through the fuel adjustment clause, aren't you transferring that risk to all other customers?
We're treating this no differently than any other special contract customer, as I
Well-
said.
Except that in year one, they're getting an 87% discount,
Well, those are tariffs.
32.7% discount from the
Again,
demand charge.
those discounts were modeled on tariff EDR and rider DRS. They're currently filed commission-approved tariffs.
Wouldn't it be more fair to your other customers that they weren't exposed to the market risk of the 2 billion kilowatt hour purchase risk?
I think it's fair, the way that the contract is designed, with the provisions that are in there, the floor price mechanism, the requirement to pay fuel. These are all protections that are in that contract.
If the market price of power is $100 a megawatt hour, $200 a megawatt hour, $300 a megawatt hour, how does the floor price protect anybody?
We don't know that the prices are going to go there.
Let's go to, Your Honor, I just have a real quick on KUC 5. The demand, 250, it's in the record, interruptibles, 2.25, firm is 25. So I know you said that you've hit every one of the PLC hours so far in your other customers, but if you miss one PLC hour, you're going to have to pay essentially 1/5 or 20% of, you're going to have to provide 1/5 or 20% of 225 megawatts, correct?
I didn't prepare this analysis, and I'm not sure I follow your math.
Well, if you miss one of the PLC hours with a 225, you're going to have to provide 45 megawatts in your next year's resource plan. If you miss all 5, you're going to have to put 225.
There are other factors, I think, that would influence that, but I'm not sure the 15% reserve margin is correct. I don't know where you got that at. You are in general correct that if we don't hit that one of those 5 CPs, we will have to have more capacity included in our next year's plan. But that's what is the, that's the important thing about the customer being on tariff DRS, is they have a tremendous incentive to interrupt when we ask them to.
Okay. And if you did miss one of the 5 PLC hours and you had to buy extra capacity, that cost would run through the PPA that all ratepayers would pay, correct?
Yes.
Okay. Now on transmission, it's the same concept. If you miss one of the 12 CP hours, you would have to, you would get assigned from AEP under the transmission agreement 1/12 of 225 or 18.75 megawatts, correct?
I'm not certain about that.
Well,
I'm not exactly sure how that calculation works.
If one of your monthly peaks was 225 megawatts higher, because you missed that peak hour, you have to provide additional, you get assigned additional transmission under the AEP transmission agreement, correct?
I believe that is correct. I just don't know that your number is correct, sir.
And whether or not customers would pay that immediately, if you're recovering transmission through the PPA, that would be, everybody would pay for it. If you're recovering transmission through base rates, essentially the company would have to absorb that additional cost.
either way, customers are paying for it, whether it's in base rates or tariff PPA. I'm not sure what you mean.
No, if you're not in a, if it's not in a test year in a rate case, I mean, you would have to absorb that additional cost if
Until
you're
it is,
recovering.
until it is recovered, yes.
Right, okay. Chairman, those are all the questions I have. Thank you, Mr. West.
So it is 10:54. We'll take a short 15-minute recess. We'll come back at 11:10, and then we'll plan to take lunch at around a quarter after 12, maybe 12:20. It'll be a short recess. back on the record in case number 2022-00387. Mr. West, you're still under oath. Mr. West, any questions from the Office of the Attorney General?
I do.
No, I'll move my exhibit to.
Oh, yeah, I'm sorry,
testimony.
Mr. Kurtz, I should have given you an opportunity earlier. Go ahead.
Oh, well, I just moved the admission of KIUC 1 through 5.
Okay. Any objections?
We don't have any objection.
All right. So admitted KIUC 1 through 5, KIUC 4 being a confidential exhibit, right, Mr. Kurtz?
Yes, sir.
Okay. And everything else is public?
Correct.
All right. Mr. West?
Yes, thank you, Chairman. I do have a few questions for you, Mr. West. A lot of the ground that I plan to cover has already been covered, but, so I'll try to make this as brief as possible. Do you recall case number 2022-181? I can read the title for you. I don't know if you recall the number off the top of your head, but this was the electronic application of Kentucky Power Company for an order approving the company's amended tariff EDR to increase capacity available to be serviced under the tariff for required deviations from the Commission's September 24, 1990 order in administrative case number 327. Do you recall
Yes.
that?
Yes, I remember.
And do you recall generally what the company was requesting in that application?
Generally, we were requesting to increase the 250 megawatt cap. I don't remember the exact number we were proposing, but that was, in general, yes.
Subject to check, was that cap to be lifted to 550 megawatts?
That sounds right, yes.
And further changes were requested, approving an amended tariff EDR to change some of the language and to request waivers from, or deviations from certain provisions of Administrative Order 327. Does that sound right?
It sounds right, yes.
To avoid handing out that application and having you read, I think I'll read a couple of paragraphs from that application and just have you confirm those, if that's okay.
Okay.
The application says in paragraph 35, Kentucky Power currently is in discussions with 11 entities for tariff EDR contracts for 12 sites. The company anticipates that if the contracts are approved and the demand would go online over the next several years. The total additional capacity is subject to the contracts under discussion is 482.5 megawatts. The three largest contracts under discussion are for 250 megawatts, 75 megawatts, and 45 megawatts of additional capacity. And then at paragraph 56 of that application, it says Kentucky Power requests a decision at the Commission's earliest convenience and no later than on or before July 11, 2022. The company is at the end of negotiations with a 250 megawatt customer and anticipates entering into tariff EDR contract with the customer, assuming the requested authority is granted no later than July 29th, 2022. Does that sound right?
It does, yes.
Okay, and so I guess I ask all that to get to the point that, is that 250 megawatt customer that's referenced in that application EBON?
They are. Initially, that's what we were thinking. But the customer, in further negotiations on the contract, had a desire to, level out their payment over the term. And that's why the additional rate design was required. So we decided that it would be better to do it as a special contract.
Okay, so what was the resolution of that docket?
The company, I believe, requested to pull the filing.
Okay, and since that application was withdrawn, tariff EDR remained in effect as if the application hadn't been filed, correct?
Correct.
And you already referenced this, but explain a little bit more why Kentucky Power decided to change course and pursue this as a special contract as opposed to a tariff EDR customer.
Well, I think there were two reasons. I think this might have been in my direct testimony that, absent increasing the cap, I mean, the load for EBON was too much. There was only 211 megawatts left unsubscribed under current tariff EDR. So that and the need for, you know, a special type of rate design that's confidential in this contract were the two drivers.
And as you discussed with Mr. Kurtz, you are familiar with Administrative Order 327, correct?
Yes,
And it's your understanding that that has a number of requirements related to EDR contracts?
it does, even though this wasn't filed, or I'll mention again, this wasn't filed under tariff EDR.
Yeah, and generally, your understanding is that many of those requirements are calculated for protecting ratepayers, right?
There are certain protections, yes, but the contract also has certain protections in it.
Okay. Just to the best of your recollection, is one of the protections in Administrative Order 327, I believe you've already discussed this with Mr. Kurtz a bit, but that EDR should only be offered during times of excess capacity.
That's what Administrative Order 327 says, yes. Our tariff actually does permit us to offer contracts, special contracts that include economic development discounts in times when we're not capacity long.
Do you have your tariff available to you to refer to?
I do not.
Okay. Maybe I can read a portion and you can confirm for me whether I'm reading from the appropriate section. But as it relates to your tariff, is it correct that it says the company will offer the EDR to qualifying customers with new or increased load when the company has sufficient generating capacity available? When sufficient generating capacity is not available, the company will procure the additional capacity on the customer's behalf. The cost of the capacity procured on behalf of the customer shall reduce on a dollar-for-dollar basis the customer's IBDD and SBDD. Does that sound like an accurate quote?
That sounds like an accurate quote, yes, but that was the deviation that we were requesting to that. It negates the benefits of offering some kind of a discount under EDR to the customer. And, you know, that order was many, many, many years ago, likely needs to be revised.
Well, this is your tariff, right?
That's right, but it's based on that order, as are the, you know, tariffs for the other IOUs.
But just to confirm, the special contract with E-Bond does not provide a provision that reduces on a dollar-for-dollar basis the IBDD or SBDD?
No, it does not.
Does Administrative Order 327 require that each EDR contract be submitted with a demonstration that the revenues generated by the contract exceed the marginal cost of serving that customer?
It does, I believe, yes, and we've done that.
Does Administrative Order 327 require that during rate proceedings, utilities with active EDR contracts must demonstrate through a detailed cost of service analysis that non-participating ratepayers are not adversely affected by EDR customers?
It does.
Did Kentucky Power discontinue the proposed amendment of tariff EDR and file this as a special contract in order to avoid the ratepayer protections of Administrative Order 327?
No, we did not. We made the decision to file it as a special contract for the reasons that I stated, as well as the ability for the special contract to require the customer to participate in Rider DRS, which has significant benefits for all customers.
Just want to ask a few questions about geared at whether this contract meets some of those ratepayer protections in 327. I'll dispense with some of them. I think you've already talked at length with Mr. Kurtz about excess capacity issues, so I won't belabor that point. But do you have your responses to PSC data requests available to you to refer to?
Yes.
Okay. I'm looking specifically at the third set.
Okay?
Can you go to request 3.6 or 3-6 and read that request and the response, please?
Confirm that during rate proceedings, Kentucky Power would be able to demonstrate through detailed cost of service analysis that non-participating ratepayers are not adversely affected by the special contract with EBON. Response: the company will prepare the cost of service analysis in future rate proceedings. While the company's estimates indicate that such cost of service analysis will show that customers are not adversely affected by the special contract with EBON, the company cannot guarantee that such analysis will demonstrate a net positive over any given year. The company does not presently have, nor would it have in future rate proceedings, known and actual information from the future to state as such.
So could one conclude from that response that, or would it be accurate to paraphrase that response as saying the special contract might adversely affect non-participating ratepayers?
Objection, Mr. West read what the response says exactly.
I just want to make sure I understand it.
Overruled, you can ask a follow-up question to it.
So my question is, whether it would be accurate to paraphrase that as saying that the special contract might in fact adversely affect non-participating ratepayers.
It's possible.
On that topic, response refers to, request and response refers to a demonstration being made in a rate case. Would, if this special contract were approved, would Kentucky Power propose to make that demonstration in the current rate case, 2023-159, or would it be, have to wait until a later rate case?
I think we would comply with whatever the commission ordered.
Let's go on to the request and response to PSC 3.7. Can you read that request and the response?
In future rate proceedings, explain which entity or entities would be responsible for any deficiency between EBON's cost of service and rates collected. Response: beyond the provisions included in the proposed EBON special contract, any delta, positive or negative, between the cost to serve EBON and the revenues generated would be included in a subsequent base rate case proceeding. The same is true for any other customer or customer class. However, the company anticipates that the cost of service analysis will show that customers are not adversely affected by the special contract.
So again, I just want to make sure that I'm understanding what's being represented here. Would it be accurate to paraphrase that as saying that if revenue from serving EBON doesn't match the cost of service, all ratepayers would be responsible for making up the difference?
It means that the differences, positive or negative, would be taken into account in the next base rate case.
In what way? I mean, I have follow-up questions, just might as well do it now. Is the amount of a special contract that falls short of the cost of service, is it picked up in the remaining cost of service study, by the remaining classes in the cost of service study, or is it picked up, is it carved out effectively and paid for by the company?
It would be taken into account, I believe, in the cost of service study for all customers, for all customer classes. I'm not an expert in cost of service studies. I don't do them. I don't perform them. But that's my general understanding. It would not be carved out for the company to pay.
Okay, so the discounts, any discounts, for instance, under tariff EDR, you're saying that if you all have EDR tariff contracts as the head of regulatory work at Kentucky Power, you propose in rate cases that discount, that shortfall in the cost of service be picked up by other customers?
We don't know that it's going to be a shortfall.
Well, it's a discount from tariff rates, so it's by definition a shortfall of what the allocated embedded cost would be from the cost of service study, right?
As long as the customer is covering its marginal costs and can make a contribution to fixed costs, it's beneficial for all customers.
No, compared to what counterfactual? Because paying a discount of a tariff rate is not better than paying the tariff rate for other customers. Would you agree? Okay, let's just, big picture. You have a customer, they have usage, they have demand, you apply it by the IGS or LGS rate, right?
Yes.
Boom. You have a customer, you apply it to half the IGS or LGS rate. Okay. Under which scenario is that customer contributing more to fixed costs?
When they're on full tariff rate.
Okay. The decrement from the amount that they pay under the discount, first what they would have paid under the full tariff rates, would look like a customer not paying their full cost of service study and a cost of service study. Just big picture, right?
Right.
Okay, so if they're an LGS customer, then LGS looks worse off compared to its cost of service than it otherwise would, correct?
They would, but.
And there's a shortfall in overall revenues for the entire cost of service study. Would you agree?
Yes, but don't we have to consider the full term of the contract and all of the economic development benefits that come to the company's service territory, as well as the increased load that in the next base case would have the effect of the fixed costs being spread over the larger load, which is good
Okay.
for customers.
Yes, I'm not talking about that at all. I'm talking about a snapshot of conducting a cost of service study and a calculation of a revenue requirement. I'm asking for EDRs, let's just start with EDRs. Do you all carve out the discounts that are provided in EDRs from the cost of service study and the revenue requirement? Or is the discounted amount picked up by remaining customers?
I honestly don't know the answer to that,
Okay.
Mr. Chairman.
And so I just asking the follow-up question, same with the special contract, you also wouldn't know whether the discount under a special contract is picked up by remaining customers in a rate case or by the company?
I'd have to look at the cost of service study to see how it flows through.
Okay, so let me go back to the question you were asked a second ago about the EDR rates. I think it's staff 3.6.
Yeah,
Okay. What do you think that how do you anticipate complying for your EDR? Forget this contractor for just a second, but this is modeled in large part off EDR, right? How
Yes.
would you intend on complying with that admin 327 case in regards to the cost of service study?
which portion of it?
Question 3-6.
I guess I meant which portion of admin order 327?
Well, the question, well, and I guess it doesn't specifically cite it, but the question in admin, the question presumes to discuss the portion of admin 327 where that you would demonstrate through a cost of service proceeding that non-participating customers are not adversely affected by the EDR. That's one of the requirements you agreed, I think, earlier when Mr. West was asking you questions. That is an obligation under admin 327.
That is, yes.
Okay, so how do you comply, the company comply with that requirement under 327 in rate cases, in practice?
We prepare an analysis and submit it with the rate case, like we did with this.
Yeah, and I'm sorry, I was asking detail, like, what kind of analysis? Is it a marginal or an embedded cost of service study?
I believe it's a marginal cost analysis.
That's what I wanted to make sure of.
Yeah.
Thank you.
Yes, sir.
Mr. West?
Just a couple more questions. If one of these analysis that you're gonna do in the future shows that a deficiency in revenue exists, related to the costs driven by the E-bond special contract, does the contract allow for the adjustment of E-bond's rate to cover those costs prospectively, or would non-participating ratepayers still be required to make up any delta over the term of the contract?
I don't believe there's anything in the special contract that requires that. There's nothing in tariff EDR that requires that either, and it complies with, it's a commission-approved tariff. It complies with admin order 327.
Forget requires, does the contract allow the company to pursue such a change to the contract?
Not that I'm aware of, other than there are protections in there for the customer to always pay fuel and the floor price mechanism.
Is it fair to say that if the commission were analyzing this special contract under tariff EDR, it wouldn't be approved without substantial deviations from Administrative Order 327?
Objection to the extent it calls for a legal conclusion.
Subject to the question. A sustained objection to the extent that it requires a legal conclusion, but you can ask your question again.
Why do you think this special contract complies with 327, Administrative Order 327?
Objection, Mr. West did not state he believes it complies with Administrative Order 327 as related. This isn't a tariff EDR contract.
I thought he said a few minutes ago that he thought it met, maybe he was referring to tariff EDR meeting Administrative Order 327's requirements, but I think it's fair to ask his opinion of whether the special contract meets in general the protections proposed under Administrative Order 327, which should at least be persuasive to the commission as to the special contract.
I'll overrule the objection. If he doesn't believe it complies, he can state as much in his response.
I believe that the special contract has adequate protections for customers as well as the company, and it provides benefits for all customers.
No further questions.
Mr. Smart?
Thank you, Your Honor.
By the way, did you all come to before we get started in earnest, did you all have a chance to discuss your
We
questions?
did have a chance to discuss it, Your Honor, and it actually directly follows up on the line of questioning that we were just listening to. So if I may, I'd like to ask a couple questions in public session, and hopefully we won't need to get into the confidential session.
That'd be fine. Just please let me know when you do, if you need to.
So, first of all, good morning, Mr. West.
Good morning.
We were just talking about administrative case number 327, and I wanted to ask, are you familiar with that one of the requirements of administrative case number 327 is that EDR contracts are for 10 years, and the discount period of the contract is the first 5 years of the contract. Are you familiar with that?
Yeah, that's correct. It could also be 8 years with a 4-year discount period. It just means that the total contract has to be double whatever the discount period is.
And does the special contract at issue in this case, would it comply with that requirement?
Yes, it would. It's a 10-year contract where discounts are provided in the first 5 years.
And this is where it might get into confidential, so please don't say anything in public session that would be considered confidential, but is that true even with the floor price mechanism in the contract?
The floor price mechanism exists in the contract for the purposes of making sure that the customer is covering its marginal costs to serve.
Well, I believe you said earlier, I have it down in my notes here, part of the reason to do this outside of tariff EDR was that the customer had a desire to level out their payment over the contract term. Is that correct?
That's correct. That's correct. That is another part of the contract. And I think all I can say at this point that part exists in the contract. That part is confidential.
Your Honor, it should only be a couple questions, but I think we
You
do.
ask as many questions as you'd like on whatever session you'd like. So would you like to move to
I think we
confidential
do need to
session?
move to confidential. Thank you.
Candace, we
Thank you, Your Honor. So, Mr. West, we've been kind of deep in the weeds. I'd like to take a step back for a bit and and some of the questions I'd prepared for today have already been covered, but I'm going to try to jump around to a few topics while I have you here.
Okay.
Just to start with, could you describe what your involvement with Kentucky Power's negotiations with EBON over, actually before I go there, can I use EBON as a shorthand for EBON International LLC?
Sure.
Is that the entity that Kentucky Power has been dealing with, is the LLC?
Yes.
Has Kentucky Power been dealing with any other corporate entities in connection with negotiations of this contract?
I have not.
What was your involvement with Kentucky Power's negotiation of the EBON contract? Your personal involvement?
I was personally involved in it, the terms of it. We involved our pricing group at AEP Service Corps to help with some of the numbers and stuff, but I was directly involved in negotiating the contract.
Who else at Kentucky Power was involved with that? Were you the lead negotiator?
I was the lead on it.
What is the current status of the EBON project?
I might defer that to Witness Clark. She's a little closer to the details on that.
So you don't know if they've begun taking any steps to begin constructing the facility?
Like I said, I'm just not up to date right now on those steps.
So you attached to your direct testimony a copy of the contract, right?
Yes.
And the contract says that EBON plans to invest at a minimum $50 million at the facility and to create at least 50 to 100 new permanent full-time jobs by June 2024. Do you remember that language in the contract?
Yes, and now those numbers have been updated. We covered that earlier.
What is the status of this? Are they still on track to move forward in June 2024?
Well, there's a lot of factors would have to fall into place for that. We had planned on them starting like around 80 megawatts and then moving up to, their full load of 250 megawatts. But, this contract is taken a little longer than was expected. And I know that the importance of it is, EBON really can't move forward without it. Without the certainty and the approval of an acceptable agreement. So I think there are a number of things that need to happen before they could hit that date. I'm just not certain what all of those are.
In your rebuttal testimony, you state that the cost of electricity was a deciding factor in choosing to locate, in EBON choosing to locate in the company's service territory. Do you remember saying that?
That's right.
How did they communicate that?
How did they communicate that?
I mean, did they just tell you that? Did they provide details in terms of how cost was a deciding factor for them?
Well, I think that, cost is a deciding factor for a lot of companies. I'm thinking of like aluminum smelting, for instance, they need to be at a certain range in order to, for their business model to pencil out, right? So it was no different for EBON where they said we need to be at a certain number. Is that going to work? And it was a back and forth, conversation, negotiation.
So they did provide a number?
It's been a couple of years ago, but I believe they did.
Is that, did they provide that in writing?
I don't think so, no.
What did Kentucky Power do to verify Ebon's claims about what it needed in order to enter into the contract?
Well, I think that what you're asking is something that the company doesn't do. And I'll try to explain. It's like a customer, Ebon or any other, would have to say, here's all of my financials. Here's everything confidential about my company. And then you're asking if the company, meaning Kentucky Power, poured over all of those financials to verify that what they were saying is correct. Is that what you're asking?
Well, just be more specific. One of the requirements for an EDR discount is that the customer, there's supposed to be evidence that the customer needs the discount in order to make the decision to locate in Kentucky Power's service territory. Is that correct?
Yeah, and I believe they did make that as an attachment to witness Clark's testimony. There's a letter from Ebon.
So the letter provided in attachment to rebuttal testimony, that's how they did that?
Well, in addition to verbally saying that this is a driver for us to locate in your service territory, I mean, initially, when we started talking with them, I'm sure that, we had those conversations. I didn't ask them for all their financial statements to prove it.
So but it's your understanding that their position is that without EDR discounts, they would not be in a position to move forward with building and operating the facility in Kentucky Power territory.
Without the contract approved in front of this commission, that includes protections in it for all customers, the Ebon cannot move forward.
So there's been some discussion in your testimony, both here today and in the written testimony, about how the contract protects customers against Ebon locating in Kentucky Power service territory and just taking service under standard rates. Is that right? That's one thing that you've cited as the contract is essentially better than if they were just to locate in our territory and we'd have an obligation to serve them under general rates.
It's absolutely better, yes, for
So-
customers.
But that's not a realistic possibility, right? Because you've just said that Ebon is telling you the only way they would locate in your territory is if they receive the discounts that are now baked into the contract.
I
right?
understand, but I guess what I would say is, I would go back to, it's no different than any other large customer that we would work with and, come to our service territory and they say we need a certain rate, we're gonna bring, this in economic development, all those things that are here today in front of this commission with this company. It's no different than any other customer and their business model, whatever that business model is. And we cannot discriminate against that company unreasonably because of their business model in favor of someone else's business model. So I'm speaking more in generalization that any other customer, regardless of their business model, would be the same.
But there's no current option on the table for them to locate in the territory under general rates, correct?
Not that I'm aware of.
You discussed earlier with Mr. Kurtz, Mr. Kurtz asked you what review Kentucky Power did of Ebon's sort of corporate finances. Do you remember that discussion? He was asking about specifically the LLC. Wanted to clarify, does Kentucky Power know whether EBON has any assets in the United States?
I believe they do, but I'm not certain. Witness Clark could probably answer that question.
Do they have any offices in the United States?
Again, Witness Clark could probably answer that question.
I believe you said earlier that eBang International is the parent company of EBON, is that right?
Yeah, I'm not sure about the international part, but eBang, I know, is the first part of it. I just don't recall their exact name.
Are you aware that eBang is a Cayman Islands-based holding company?
No, I was not.
So I believe in response to Joint Interveners 1-14, you stated that Kentucky Power reviewed publicly available records through the Securities and Exchange Commission. Do you recall that?
If that's what it says, we did that.
And so you don't recall whether those publicly available records cite a Cayman Islands-based holding company as the parent company?
I do not recall, no.
And eBank's corporate offices are in Southeast Asia, correct?
Witness Clark could probably answer that question.
In your direct testimony, you mentioned the possibility of breach of contract remedies as a possible backstop here in the event that the protections built into the contract aren't sufficient to protect ratepayers. Do you recall that?
Yes.
Did Kentucky Power do anything to review how much of an ability it would have to enforce contractual obligations against EBON International LLC?
I believe that our counsel did.
Your Honor, I have a couple more lines of questions. I know you said you wanted to take a lunch break around this time, so I don't know if now would be a good time or if you'd like me to
Is
proceed.
this a convenient time?
It is.
Is it an actual break in your?
Yes.
That'd be fine then. Okay, we will take a recess until 1:15. We'll come back and continue with Mr. Smart's questioning. Before everybody, Mr. Kurtz is hungry. Before everybody goes, I have a full intention of finishing this hearing today. Does anybody object to going until we're done today?
No.
All right, we'll come back and finish with Mr. Smart.
back on the record in case number 2022-00387. Mr. West, you're still under oath, and Mr. Smar, if you have additional questions, you can ask him.
Thank you, Your Honor. Good afternoon, Mr. West.
Good afternoon.
I'm going to start by following up on something you said earlier before the break. At one point, I don't recall, I apologize, I don't recall who had asked the question, but at one point you said they, by which I took to mean Ebon is committing to several other projects depending on the outcome of this case. Do you remember saying that?
Yes, I do.
Could you explain what you mean by that?
Well, it's my understanding that Ebon has an interest in a couple other projects. Witness Clark probably has more details on it than I do, but just in general, they'd like to have them co-located with this project. So without, without an approval in this project, not only do you not have the benefits of economic development in the county that we've talked about, but it could be that these other projects don't come to fruition as well. And they have a significant amount of jobs.
Could you have a sense of what the load would be associated with those additional projects?
I don't. It's not anything like the 250 megawatts that we're talking about. It's megawatts, but it's not 250. I just don't have that number off the top of my head.
But would it be fair to say that 250 megawatts is not the maximum load that Kentucky Power could ultimately be requesting come online at this site?
Well, it wouldn't be, it wouldn't be at this site because there's not sufficient space for all of that. I guess what I mean by co-locate is, they could be around our service territory, still in our service territory, not next to each other or anything, just in the same vicinity.
When we were talking earlier about the negotiations with Ebon, they were, I believe in response to Mr. West's questions, you noted that those negotiations were originally with the idea that they would come in under tariff EDR. Is that right?
That's how it started.
Did Ebon fill out, so in discovery responses in this case, in particular, I'm looking at Joint Intervenors 1-15, Kentucky Power provided documentation concerning the process that the company ostensibly goes through to evaluate cryptocurrency-related projects. Is that right?
In Joint Intervenors 1-15?
1-15. And so attached to that response, there's something called an application for economic development rider discount, and there's also something attached called a economic development questionnaire. Is that right?
Well, I remember the response you're talking about. I just don't see those attachments as part of 1-15. Are you sure that's right?
Oh, I'm sorry. I'm looking at the wrong thing. Could you check 1-18?
I believe Witness Clark sponsored that one. I don't have a copy of it in front of me.
I see. Well, you were the lead negotiator on the Ebon contract, right?
Yes.
Do you recall if they filled out an application for an economic development rider discount or an economic development questionnaire?
Honestly, I don't remember. That's been too long ago.
But nothing like that's been filed in the record of this case, right?
Not to my knowledge, if it exists.
And so you don't know whether it exists or not?
That's correct, I do not. I don't recall.
Could you turn to the company's response to PSC 1-2?
Okay.
I believe you mentioned this earlier, right? This is attached to this response. There are a couple of maps of the Big Sandy site.
Yeah.
What is shown, well, I guess let's do them one at a time. What, the attachment 1 here, could you just briefly describe what's reflected in attachment 1 to PSC 1-2?
It's an aerial view of the site, or part of the site that EBON would locate on, next to the Big Sandy Generating Station. And what is indicated there, when it says mobile, that would be a mobile transformer installation that would allow them to start operations at that lower level in year 1 until such time as they were able to build their substation.
Is there anything else indicated in attachment 1 here that's related to the proposed EBON facility?
I don't think so, no.
Could you turn to attachment 2
Uh-huh.
and describe what's reflected there?
It has a proposed container layout, as well as indicating where the customer's substation would be at.
There's a rectangle on the left side of attachment 2 that's not marked, but appears to be potentially a building. Do you see what I'm talking about?
Yes, I think that's a warehouse.
Oh, and is it an existing warehouse, or is it one that is yet to be built?
No, it's there.
What's in the warehouse right now?
I don't know. I don't work at the Big Sandy site. I've only been there a number of times, and I don't go over onto that part of the territory or property, I guess you'd say. I'm sorry.
But that's a Kentucky Power warehouse.
It's part of the site, yes. It's owned by Kentucky Power. It's Big Sandy owned.
Would EBON be using that building as part of its proposed facility?
I don't know. I'm not sure.
Do these drawings in attachments 1 and 2, do they reflect a complete representation of the proposed facility?
I'm not sure about that. These drawings go back a little ways in time. I think they were complete at the time they were done, whenever that was.
Are there any other buildings that are planned to be constructed on the site as part of the proposed EBON facility that are not reflected in one of these 2 attachments?
I don't know.
Is EBON planning to build any office buildings at the site?
Again, I don't know for certain.
Well, they're proposing that, they've claimed that they'll be creating as many as 100 or more jobs. Presumably that would require offices, right?
Well, I assume that the employees need to work somewhere besides in the container area. I'm just saying that I'm not personally aware of what buildings are planned.
So that's not been part of your Kentucky Power's discussions with EBON, whether they're gonna be building
Not-
offices?
Well, not with me, they haven't. I mean, I was the, responsible for the contract, for the rate, not specifically what buildings and things they were going to construct.
But that's not directly controlled by the contract or anything like that, right? There's nothing in the contract that commits them to building office buildings.
Not that I'm aware of, no.
Is EBON gonna build a parking lot for the employees?
I honestly don't know, sir.
Because presumably if they're coming to work, they need a place to park, right?
Well, I don't disagree with you. They can't park along the side of the road, but I'm just saying I am not aware of where that parking facility would be. It's not been discussed in any of the discussions I've been part of.
The EBON facility is planned for 24-hour operation, is that right?
That's correct.
Do you know if there are plans to put in any lighting around the containers?
I don't know if there are any plans or not.
You turn to the response to Joint Interveners 1-8.
I do not have a copy of that.
Oh, I see, it must have been answered by witness Clark. Well, let me ask you, were you involved in the negotiations of the lease of land to EBON?
No, I was not.
So those are questions for witness Clark?
To the extent that she was involved in those negotiations, yes.
Was there anyone else from the company who was involved in those negotiations?
As far as I know, there were folks from our real estate group, as you would expect.
Just while Mr. Smarr's looking up, do the folks with the real estate group work for Kentucky Power, or are they agents of Kentucky Power?
They would be Service Corps employees that would do real estate for all of the operating companies.
Okay, so not necessarily, well, not necessarily, not employees of Kentucky Power.
That's right. That's right.
Could you turn to the response to Joint Interveners 1-9, which I believe is one of yours?
Yes.
So this response discusses the transmission implications of the EBON load locating at the Big Sandy site, is that right?
Transmission grid or infrastructure investments that the company would incur, that's what it's asking about, yes.
Did Kentucky Power look into whether there would be any transmission issues associated with EBON operating at times when the Big Sandy gas plant is not online?
I don't know specifically what they looked at, but it's my recollection that whether the Big Sandy site was in operation or not was not a factor.
And who's they?
Our transmission group that would have done the analysis, the transmission planning group,
Is that analysis in the record of this case?
I'm not aware that it is, no.
Did Kentucky Power look into whether if the Big Sandy gas plant were to retire, it would have transmission implications with the EBON load on the system?
I don't know.
Your Honor, we would request to have the ability to ask a post-hearing data request on this line of questioning.
That'd be fine. You've asked all the questions that you would like to ask post-hearing already? Or you think that just not, he doesn't know the answer, so you're saying you're gonna follow up post-hearing?
That's, the two questions that I just asked are the ones we would put into a post-hearing data request.
That'd be fine. We'll have a discussion about that at the end of the hearing today. Thank you.
All right, well, I think one last area for you, Mr. West. There's been a lot of discussion today about rider DRS, and I don't want to cover all the same ground, but a couple quick questions. Do you know who is the largest current customer of Kentucky Power under rider DRS?
Largest in terms of load,
Megawatts, yeah.
megawatts? I don't off the top of my head.
Do you have a sense of the size of that customer? Like, are there other 250 megawatt customers under rider DRS?
It runs in my mind that it's like 25?
25.
Yeah, I'd have to check that, but that's what's coming to mind.
I believe it was a work.
250.
I'm sorry to interrupt you. Could you repeat the last part?
Oh, I said it's not 250. It's 25 or so.
Was this provided, there's a workbook provided, I believe, in response to PSC 1-7. Does that ring a bell?
Yeah.
Would that be an appropriate place to look for this information?
It would be, but I don't know. I think it indicates the amount of load that they dropped, but not what their total is.
I see. Would it be fair to say that, I mean, here in the contract, it's contemplated EBON would be dropping 225 megawatts of load, is that right?
That's correct.
And that's significantly larger than the other customers that have been operating under this rider, right?
That is correct, yes. It's significantly larger.
If EBON fails to curtail, the most they can be penalized is loss of some portion of the DRS credit, is that right?
Not necessarily. I mean, that's part of it. But the reason that EBON would have such a reason to comply with the curtailments is, and we talked about this a little bit before, that if we miss one of those 5 CP events, then certainly the company is going to have to acquire more capacity in the next PJM year, in the next year, and those costs would come back to EBON.
Mm-hmm.
So it's
those
not
costs
only
would-
that
I'm sorry.
it's not only that they're going to lose the discounts, but they're going to increase their costs overall. And it's certainly not in their interest to do that for the remaining term of the contract. So, and besides that, their business model is very conducive not only to great load, meaning that it's high load factor, it's very consistent, it's the kind of load that any engineer would tell you that's the exact load we want, because it's predictable. But their business model allows them to interrupt fairly quickly. You know, when you have a traditional manufacturing organization, it's sometimes difficult for them to come down quickly. And that's not the case here with EBON. They can come down pretty quickly.
EBON's core business, though, is they're mining cryptocurrency, right?
They are mining cryptocurrency, but they are a blockchain company. And one of the data responses, the early staff responses, we explained that they have the ability to pivot to other businesses, meaning that their computers can do more than just mining cryptocurrency. They can do a lot of different things.
Sure.
Should cryptocurrency not be economic at that very time, they can pivot very quickly and do other things with their technology.
But let's say cryptocurrency becomes extremely economic. Let's say, for example, the price of Bitcoin goes extremely high, as there's been reporting that there's, without expecting you to know these details, Bitcoin goes through a process where they have sort of boom and bust cycles, and there's a boom cycle that's been predicted for next year, for example.
Okay.
Let's say that the price of Bitcoin is extremely high, and the EBON facility is operating and earning a lot of Bitcoin by operating at a particular time. Wouldn't that then be for them an economic calculation as to does it make business sense for us to curtail when we've been called on, or does it make sense for us to keep mining Bitcoin through these 3 hours because the price of Bitcoin is extremely high? Isn't that a risk that you all
Well-
bear, that they wouldn't curtail if it's not in their economic interest to do so?
I understand your question. Here's my thought on that. It would be very hard for them to do the math quickly on that, meaning that they can't reliably predict what that increase is going to be. I mean, they would know that they might get clawed back on the credits, right, the DRS credits, but what is that impact going to be long-term for the cost of higher capacity that they're going to incur through the rest of that contract? It'd be real tough for them to do that math quickly and say, we've got to run our machines and ignore this interruption request. Now, the other thing you have to think about is, it's my understanding that the whole Bitcoin mining thing is a competition between, like, let's say my machines that are mining Bitcoin and your machines that are mining Bitcoin. And the one that reaches the calculation first or solves the algorithm first is the one that wins. So even if EBON were to say, wow, the price is really high, it's still pretty risky for them because there's no guarantee that if they run through that interruption that they're going to actually, their machines are going to actually win that competition with the other machines and earn the Bitcoin. So it's pretty complicated math for them to make that kind of a call quickly.
But presumably that's a key part of their business, right? Is they're going to be developing models that will tell them when it's economic for them to run and when it's not. That will be part of how they make their operational decisions. Is that fair?
I do not know that for certain, sir.
And you mentioned the risk that they would have to incur additional capacity costs in the future, but I think as we've discussed previously today, the risk of bearing the future capacity costs would be shared with other customers. That would not be under your proposed contract. That would not be solely EBON's risk to bear.
It would not be solely EBON's risk, but they're going to pay the higher costs as well.
So, but other customers would get pulled into this consideration of whether EBON decides to keep operating at a time when they're being called on to curtail. The other customers would be essentially held hostage to the value of the cryptocurrency mining that EBON is engaged in.
It's possible, but it would be no different for any other customer that makes aluminum, for instance, and because the price of aluminum is high, they say, I'm not going to interrupt today. So this is not a unique situation to cryptocurrency mining. It could be the exact same situation with a traditional manufacturing company that makes anything you want to mention. It's not unique to EBON.
Except that EBON is also receiving economic development rider credits too, right? So
So could
those-
other customers that make the same decision.
if EBON fails to curtail its load when called on under rider DRS, that does not affect, under the contract, whether they would continue to receive the economic development discounts. Is that right?
That's right, they're two different things.
And because of EBON's potential size here, they're continuing to operate in the possibility that they would, that would result in greater capacity costs in the future. That's just a magnitude greater than other customers on Kentucky Power's system. Is that right?
I don't follow your question.
Well, so we discussed earlier that under rider DRS, all the other customers are much smaller, right?
They are.
And so the risk associated with a smaller customer failing to curtail is also going to be smaller than the risk associated with EBON, since it's so much larger. Is that fair?
There is an increased risk due to the size of the load, yes.
That's all the questions I have, Your Honor. Thank you. Thank you, Mr. West.
Mr. Young, Mr. Floyd?
I do have a few questions. Good afternoon, Mr. West. I just have a few questions for you. Can you hear me all right?
I can, yes.
All right, thank you. With the size that the EBON load is going to bring to the system, is there any risk that it's going to move the local marginal price for energy?
I'm sorry, I don't know if that would happen or not.
Okay, is it a possibility that could happen?
Again, I'm not certain. I'm really not that familiar with how that would affect the market.
Has there been any conversations or discussions throughout all this about also building any sort of natural gas combined cycle or any simple combustion turbines on that same facility?
In connection with this contract?
Just in general
Or-
with that, with the property that's going on. I believe you tendered a map. We discussed it a little earlier. It was data response, the first response to staff's first response.
Yeah, it was like,
It's just on that map. Has there been any discussion of putting any generative capacity on that site, additional?
it's something that the company is considering. Our IRP calls for, the possibility of a CT or even a CC. And the Big Sandy site does have some characteristics that would make it good for that possibility.
So is there still enough room on that site once EBON is fully built out to do that if Kentucky Power desires?
Actually, there is.
Okay.
The current plant manager, well, he's moved on to another plant now, but at the time, he was our current plant manager, and he went out and walked the facility, and he compared it to the footprint of current known CTs in the system, and he said he thought that there was room.
Excellent. Thank you. You sponsored data request or response to staff's first data request, response 4, attachment 2. It's titled Kentucky Power Annual Internal Load 2023-2034. Do you have that in front of you?
Yes.
About halfway down that form, there's a row that says other sales for resale, total sales for resale. Do you see that?
Which attachment again was it?
Should be attachment 2. It's actually part of the narrative on that one. So it follows the question in the data response.
Oh, okay. Oh, okay, what was your question now?
About halfway down those rows, there's one that reads other sales for resale, total sales for resale. Do you see that?
Yes.
Is that the municipals that you sell to? Or what customers are included in that?
Yeah, I believe that is our wholesale load, yes, because after May 31st of '25, they drop out of our forecast.
That you led me right to my next question. So why do those drop out of the forecast?
Well, the cities of Vanceburg and Olive Hill had told us that they wanted to go out for an RFP instead of renewing their contract with Kentucky Power. And at the time that we were, at the time they were working on that RFP, we were just not in a position, due to the potential sale with Liberty, of being able to put some kind of a proposal out there for them that would be a cost-based proposal. And they were looking for something that was more market-based anyway. So we really just weren't able to put a proposal out in front of them.
Is that the only customer that falls into that section, that category?
I think so. It's just the wholesale customers.
Have there been any changes since then? Have they come back to you all? Do you know if they've made other arrangements? Do you know if there's been conversation they're definitely going to be ending the service on 2026?
They've not told me anything definite, no, just what I told you.
No. It's my understanding from the questions that have been asked that there's a generative capacity deficit overall in regards to meeting your peak demands. Is that correct?
Own generation?
Kentucky Power, can it generate enough to meet all of its peak demands throughout the year?
Kentucky Power-owned facilities cannot, but what we cannot, we contract for in the market.
Gotcha. It's a post-hearing data request, KRS 278010 subsection 14. It defines adequate service in part as having sufficient capacity to meet maximum estimated requirements. Could you guys provide an explanation in a post-data hearing request to how Kentucky Power satisfies that?
Are you asking if we would?
Yes.
Yes,
Yes, thank you.
yes.
No further questions, Your Honor.
Question?
Mr. West, can you hear me okay?
Yes,
I'll move the microphone a little closer. Is that better?
that's good, yes.
Good, okay. Along those same lines about capacity, we've heard lots of concerns about capacity, and especially after 2028, when the Mitchell plant is to be retired. I know that that's on a lot of people's mind, about being under capacity. And so I understand the concept of economic development principles, that we would want to attract large customers like this, to spread out the cost sharing among your residential customers, and that's the whole point of giving these sort of riders, even though it's not an EDR, it's, the reasons for it have been similar to the EDRs. But I'm wondering if you have to buy capacity for this customer and for any new customers that this customer might lead to, if it hires 100 people and they have to come in, that's more capacity. If similar industries spring up to complement this, that's even more customers that are coming in. And if you're having to buy capacity, does that negate all of the benefit to your current customers? Potentially residential, especially.
I don't think it negates it. I think it depends a lot on what the cost of that capacity is. And long-term, you know, we're looking at a lot of different things, you know, in the IRP analysis. It's not just, you know, shoring up indefinitely through the market for, you know, bilateral contracts for capacity. But, you know, the company's looking at owned resources as well as purchase power agreements. So it's definitely gonna be a mix of all those things. Does that help?
Yeah.
Okay.
We also know that fuel adjustment clauses have caused a whole lot of volatility and some increased hardship on residential customers. So, given how much fuel is gonna have to be purchased in order to meet the needs of this customer, why would that not create a multiplied effect for your residential customers who've already faced some hardships with fuel adjustment clause volatility?
Why would it not create what, did
A
you say?
multiplied effect
A multiplying
of the
effect?
current problems with the fuel adjustment clause volatility.
Well, the volatility, keep in mind that, you know, our fuel adjustment clause, although it lags by about 2 months, it doesn't create a large deferral, okay? Like some other companies have. And what I mean is, you know, if you set a rate that is, like the same, it's a static rate for 12 months, in other words, and it could be based on a forecast. But, you know, we've seen in other companies where that kind of a thing can lead to a large deferral. And then, you know, a company has, you know, hundreds of millions of dollars potentially in deferred fuel costs that they need to collect. And yeah, I think one thing you have to consider is the month-to-month volatility I get, right? But, you know, if you try to level that out with what I'm describing, and you have the potential situation of creating a large deferral, that's also not a good thing, because now how are we going to recover hundreds of millions of dollars of fuel costs that were deferred? So I understand your point about volatility, and what I would say is that additional purchases would maybe I'm not sure it would increase the volatility of it as much as it would maybe just increase the overall cost of it to some degree. But I did want to address the volatility piece with the potential downside, I guess, of having something that's like the same for, 12 months.
But you would acknowledge that it has the potential to increase the overall cost. If we're buying more fuel than that, I mean, it's much easier to predict what it's gonna cost to generate fuel.
It's possible, yes, it's possible.
And is this only good for customers if the cost of fuel that's attributed to EBON costs less than what we're paying now?
Well, it's good for customers in that we're adding the load that you mentioned, where you can spread the fixed costs over larger load. And the economic development benefits that come with this project. Absent this contract, absent EBON coming to the area, or any large customer, that we can attract to the area, there's no economic development benefits for Eastern Kentucky. There's no additional jobs. So I think those benefits have to be considered as well.
And I know that we're being asked to consider those benefits, but we're not looking at an EDR. And for something that was not filed as an EDR, we sure have talked a whole lot about EDR provisions today and being asked to consider a lot of the positive sides of an EDR without the negative sides is sort of what it feels like to me. But since we're comparing, a lot of EDR rates have built-in conditions and clawbacks to make sure that the benefits are clawed back if the jobs don't materialize. We don't have any such requirement in this because it's not an EDR. Earlier you mentioned you thought there were some clawbacks. Can you find any specific references to those?
I was able to clarify that, and what I was referring to is, and I did answer some questions regarding this, that we had started these conversations with EBON, kind of planning that this would be, based on Tariff IGS, Rider DRS, and Tariff EDR. And of course, that clause is in Tariff EDR, so that was in my mind. And that's why I was thinking that certainly we had that in the contract somewhere. Mr. Kurtz is correct, it's not in the contract as I had thought it was. I was thinking about the tariff because that's where our conversations with this customer had started. I've since been able to discuss this with our counsel and with EBON, and they are agreeable to amend the contract or to execute an addendum that would put that provision exactly like it is in tariff EDR into this contract.
Provision about job creation?
Provision about clawing back the discount should they breach the contract in the contract term.
If they breach the contract during the contract term, but the
That's
contract
correct.
still doesn't have the general clawback provisions that we would expect in an EDR.
And you're referring to the incremental piece on the jobs.
Yes.
We did not discuss that with EBON. We talked about the EDR discounts and the clawback that's in the tariff.
Okay. And that's not something that would be filed as an addendum to this rate case? Or, I mean, to be considered in this, not rate case, but this specific special contract case? It's something you would say we could expect in the future?
I did not discuss the timing with EBON. I can certainly do that.
Okay. So I guess just the concern is that what happens if Kentucky Power doesn't make money on this case in the next 10 years? Who's going to absorb that risk? Is it going to be your shareholders or is it going to be your customers?
Who is going to absorb the risk? Well, it depends, I think. I guess it could be a little bit of both. It depends on what the failure is. Is it a bankruptcy? I don't know, and I'm not a bankruptcy attorney. I don't know exactly how all that works when companies file for bankruptcy, for instance. I really can't answer that question.
So there's a current rate case. It's not based on a forecasted test year.
That's right.
I think maybe there'd been some indication we'd see or should expect a forecasted test year, but it's based on a historical test year, and we're not seeing any of this potential benefit in your current rate case that would go into effect over the next few years. It's asking for substantial increase in rates, and I guess if this EBON project creates positive margins, should we expect that you're going to file a subsequent rate case in the next several years that would then turn around and ask for a residential rate decrease to show those positive margins? Because for now, everyone's rate's potentially going up, and we're not taking into account any of this. And I want to understand how a residential customer can expect that they're going to benefit from this.
It's hard for me to say when the company might consider filing another base case. I guess it depends in great detail of how this rate case comes out. And how costs, do interest rates continue to climb as they have? That's been a big expense for Kentucky Power, and it has been for all companies. It's difficult to answer that.
Residential customers, and I didn't mean to interrupt you if you weren't finished with your,
No, please, go ahead.
residential customers have been told for years that when we get economic development, investment, that their rates are going to go down. And that the reason their rates are up is because we don't have enough customers and it's being spread across. But right now, we're looking at a substantial increase and no idea from Kentucky Power when something like this might be reflected in any kind of a request to decrease their rates. Do you see what I'm saying?
I see what you're saying. I just can't sit here and tell you today when that would happen.
So we had a public comment earlier that mentioned a $300 million investment and 1,000 jobs, and there wasn't much detail provided. You can't question a public commenter. But the comment was that that project would be directly dependent upon whether this contract is approved. And we've heard all sorts of other potential contracts with this company or others that may be dependent on this rate being approved. Do you know whether there are specific other contracts out there that are reliant upon this being approved? That's a big deal, and we don't have any information about it.
Again, Witness Clark would probably be the best witness to answer that question. I mean, well, I had replied to some questions from the joint interveners where I described these other two projects just in general, that EBON was wanting to kind of co-locate them to where, you know, they're not on the same site, but they're in our service territory, okay? And what I was saying is that if they're not able to continue with this project here, okay, then it's my understanding that they would go somewhere else where they can put those projects, where they can co-locate them in a region of the country.
Someone said the word multiple other projects. I don't recall if that came out of your mouth or if someone else said the word multiple. Are we just talking about those two?
I think it's two. That's all I've heard of.
And are these other potential projects, like the one that the public commenter talked about from the Ashland area, would that be because of the investment in the substation and transmission upgrades that others would rely upon? Or do you know how they would be relying upon those?
Would you care to maybe ask Witness Clark that? She has more details about it.
I can do that.
Okay.
Thank you.
Good afternoon, Mr. West. I just have one quick question, and I'm not sure you're the appropriate person, but
Okay.
in talking about the jobs, do you know how many of the 115 will be located in this area? Are you do you know if they're gonna hire local people to fill those positions and
Yes.
train them?
Yes, it's my understanding that they will train and they will hire locally.
Okay, great, thank you.
Yes.
All right, we're gonna take a quick recess. We've been going about an hour, so we will take a 10-minute recess until 2:20 and we'll come back. Thank you.
Back on the record in case number 2022-00387. Mr. West, you were asked a couple questions earlier about the, we'll call it the dollar for dollar IBDD payback. Do you know what I'm talking about when I say that?
Which one is that, the IBDD?
Yeah.
Is that the,
So, I'm pretty sure it's the, well, I say it's IBDD, but it's, hold on 1 second.
is it the jobs or the load? I think it's the first one, the load.
Yeah, well, you were asked questions about the, really the incremental billing demand discount.
Okay,
You remember that? And there's also the supplemental billing demand discount.
that's right.
The IBDD, correct me if I'm wrong, the IBDD is the one that's like 50, 40, 30, 20, 10, right?
That's right.
And then the SBDD, the supplemental one is based off of job,
Yes,
meeting job thresholds. Those are EDR provisions, is that right?
they are, yes.
Are those similar provisions, are those provisions from EDR mirrored in the contract?
Yes, they have different names, but they were modeled after what was in Tariff EDR.
Okay, and that's that, with IBDD, that's the 5-year discount, and the contract length is twice the length of the discount, and that's the 5 years and the 10 years that we have in this contract, is that right?
That's right.
You were asked questions earlier about, the provision, or a similar provision, it was specific to the EDR provision. The terms and conditions that talk about when the new or increased load occurs at a time when the company does not have sufficient generating capacity. And that the current terms and provision of that tariff allow the company to reduce dollar for dollar, is the term that's used in the tariff, dollar for dollar, let me get this exactly right. The IBDD and the SBDD based on the cost of capacity procured to meet that customer's demand. Are you aware of that?
I believe that's what it says in the contract.
Okay, and Alex should read, I've got EDR here in front of me.
Okay.
From our website. The cost of capacity procured on behalf of the customer, this is at times of insufficient generating capacity, on behalf of the customer shall reduce on a dollar for dollar basis the customer's IBDD and SBDD. Okay.
Yeah.
You were asked a question specifically earlier about 2 contracts that might have had an exemption to that. Do you remember being asked that question?
Yes.
Do you remember what contracts those were?
They were for 2 cryptocurrency contracts under Tariff EDR
Okay.
that were filed last year, I believe.
Okay. And you're generally aware of the contracts? You saw them before
Yeah.
they were filed, or you made the filing, or
Yes.
something along those lines? Okay.
Yes.
So I'd like to ask one of our council to bring those contracts up so we can look at them just for a second, given that that provision was discussed. You should be able to see it up here in just a minute. Great. Have you seen this page on our website before?
I believe so, yes.
Oh. Okay. Have you seen this page on our website?
It'll be just one moment, I apologize.
All right, it may be easier if you'll close out the other things, it'll run faster. Give it just 1 second, Mr. West. Are you generally aware of this page, of its existence? This is the tariffs library for contracts for Kentucky Power Company.
Mm-hmm.
Okay, so if we could scroll down here, one of those entities, both of them were tariff filings that got approved without a commission order, right?
That's right.
Okay, and so the first one is Cyber Innovation Group, is that right?
Yes.
Okay, so if we could click on Cyber Innovation Group. You don't want to zoom in too much. Okay. So here's the contract. And if we can scroll up just for a second. Oh, here, actually, perfect. So this is the copy of the contract. You see attachment 1, page 26 to 26. And then there's the PSC's official stamp at the bottom of the page.
Uh-huh.
Okay, if we could scroll down onto the final page of this. Just so we can see paragraph 3. That's fine. So paragraph 3, tell me if you're reading the same thing I am. Customer has been provided a copy of the company's tariff EDR. Customer recognizes that during the term of the contract and addenda, that Kentucky Power may be required to acquire additional capacity on behalf of customer. In the event the company is required to acquire additional capacity on behalf of customer recognizes and agrees that customer's IBDD may be reduced in accordance with paragraph 1 of the terms and conditions of tariff EDR, tariff sheet 37-1. Would you agree that this contract provides for the dollar-for-dollar reduction in the IBDD in the event the company does not have sufficient generating capacity?
That portion of the contract was to make sure that the commission knew that we had discussed the possibility, should the commission not approve the contract with the deviation that we requested in our cover letter. And I think if you would scroll back up to the cover letter, it's well documented what we were requesting, and the commission approved this contract.
Commission approved it, or it went into effect?
It went into effect, it was a tariff filing, and I think we got a letter saying that, I don't remember exactly what the letter said, but typically we get a letter on these, I think.
Did the commission enter an order?
I don't think they issued an order.
Okay, so this is effectively a tariff, correct? The special contract is it's a piece of
It's a-
paper that provides rates and service, right?
Well, it's a special contract that the commission said from now on, after Big Run, you should file them in the tariff filing system. So it's a contract that we filed in the tariff filing system.
And the contract says what I just read in paragraph 3, is that correct?
It says that, but what I'm trying to say is that we asked for a deviation, we asked for clarification, the commission granted no clarification on it, they approved the contract.
Okay, so I'm
Therefore-
confused then how the commission granted clarification if the commission did not grant clarification.
Well, by not saying that they had a problem with it, in our minds, that's approved. It was in the cover
Let me be
letter.
very clear from your last answer. It's your impression and understanding that the commission granted you a deviation by not saying anything when the terms of the agreement that went into effect do not reflect a deviation from the tariff provision.
It was my understanding, yes.
Okay. Do you mind to pull go back to the original page with the tariffs? That'd be fine. Okay, and the other one was with Discover AI LLC, is that right?
Mhm.
Okay, do you mind to
Yes.
go to that? And then again, I think it is towards the end of the agreement. Oh, actually, no, it's not. It's right there. Scroll up, I know it takes a second. Okay, would you agree, and I know it's cut off, which is just really helpful for this line of questioning, Mr. Webb. But would you agree that section 4.9 in this contract appears to be similar to the one we just looked at in Cyber Innovative?
Yes, I would agree.
And that would also reflect that there could be an IBDD reduction dollar for dollar to the extent pursuant to tariff EDR that you all do not have sufficient generating capacity and would need to purchase that capacity.
And this contract as well had the same cover letter, the same request for deviation, and it was approved in the same manner.
And do you remember if the commission entered an order granting the deviation in this matter?
I do not.
Okay. So these were not necessarily big contracts. Would you agree? I
That's
mean,
correct.
they're big compared to Bob's Muffler, but they're not big compared to a 250 megawatt computing center, right?
That's correct.
Okay. They were, actually, they were good size. In the neighborhood of a megawatt? Is that your understanding?
That may be their firm.
And then, yeah, well, a megawatt and a tenth of a megawatt firm, respectively. One was a megawatt firm and one was 1/10 of a megawatt firm.
That doesn't sound right to me.
Okay, that's fine. But they weren't 25 megawatts firm and 225 megawatts subject to DRS.
They weren't that.
Yeah.
That's right.
Significantly smaller than that.
Significantly small.
Okay.
We can agree.
And let's just go off let's assume, because it's in the neighborhood, yeah, thank you for that. Let's assume that capacity can be purchased, capacity that can also provide you energy. Let's just say that for a second. Capacity in PJM can be purchased for $35 a megawatt day. Is that about where the last BRE clearing price was that you remember?
I think it is. I think it was 34.17 for
Yeah,
some
I didn't remember
reason.
I didn't remember the next two the tenth and the
Yeah.
hundredth. So it's about $35 though.
Yeah, I think so.
Okay, so to figure out what the cost of a megawatt would be, you would take the dollar per megawatt day and just multiply it by the number of days, right?
Yes.
Okay, so $35 a megawatt day times 365 days in a year. The capacity cost of 1 megawatt at $35 a megawatt day would be $12,775. Does that sound about right?
Yes.
Okay. Relatively small purchase, correct?
Yes.
Okay, 25 megawatts would be $319,000. Does that sound about right? 25 times bigger than that?
Yes.
Okay, 225 megawatts would be 9 times more than 25 megawatts. Would you agree?
Yes.
Do you know how much that is?
I don't.
$2.8 million a year. So even if the dollar for dollar discount applies to the other two contracts, you would agree this is a different magnitude altogether. If other customers have to purchase the capacity on behalf of EBON as opposed to EBON being passed dollar for dollar as a discount, as a reduction to its discounts, their own capacity purchases.
It is a different magnitude, yes.
Okay. And that's effectively, in large part, or in certain parts, the 250 megawatt portion, or the 225 megawatt portion, is effectively, the risk of having to do that comes down to the ability of the utility to, with specificity, avoid allocation, certain peaks under DRS that result in allocation of expenses. Would you agree with that?
Yes.
And that's that 5 CP that was being discussed earlier.
Yes.
Okay. That's under the current rules. Would you agree?
Yes.
Okay. Have you heard anything, even generic or in passing, that the rules around the allocation, of the capacity market in PJM, or changes around what the FRR compliance with capacity rules are, that those are either being discussed to be changed or are proposed to be changed?
I've heard that PJM is considering a winter requirement, so I think that they would, again, my understanding is they would keep the summer requirement, it would be seasonal, and that they would add a winter seasonal requirement.
Okay.
That's what I've heard.
Does that raise the risk? Let's just say that it goes from a 5 CP and the CPs are spread or mixed, even if it's still at 5, spread between winter and summer. Up to now, when you were talking about your success up to this point in the company's success, excuse me, in avoiding certain allocating peaks under DRS, that experience has been under the summer 5 CP regime. Would you agree?
Yes.
Does the company have experience avoiding winter peaks under DRS?
I believe, yes. I believe the answer is yes.
Okay.
I'm not terribly familiar with what they do around the winter peaks, but as you know, Kentucky Power is winter peaking, so it does benefit us if we can reduce that in some manner.
Okay. So as a post-hearing data request, I'd just love to follow up because I believe there's information in the record about how you all have avoided summer peaks, for instance, from the side 5 CP before. But, you know, if there's somebody else that can speak to your history or experience in avoiding winter peaks under DRS, that would be helpful.
Sure.
Other utilities in Kentucky have programs that allow for interruptible load, right? You guys aren't unique in that. DRS is not a unique rate structure. But many of them allow for a buy-through provision. Are you generally aware of what a buy-through provision might be for this? Does DRS allow for a buy-through?
I don't remember reading that in there.
Okay. I don't think, I've not seen that it does.
I don't think it does.
Why would a utility customer buy through when they're being asked to curtail?
Well, it goes back to, assuming they can do an economic analysis and say, it's cheaper for me to pay the buy-through because I'm making so much money over on this side.
Yeah. Yeah, and then
general.
eventually, I've seen ones that even have buy-throughs, but eventually there's a reliability stop. Are you aware of that?
Yes.
Yeah, it's so like, I'm generally aware of LG&E and KU's CSR program, Curtailable Service Rider, that allows you to buy through, and then once LG&E and KU are spinning their very last combustion turbine, or their second to last combustion turbine, when they're out of power, you could offer them all the money in the world, and they're gonna tell you to turn off because it's a reliability prerogative. Is that generally you're aware of that?
I've heard of those, yes.
And your all's DRS doesn't necessarily have that, correct?
No,
Okay.
no.
If it's a reliability prerogative, and it's, forget for a second your all's tariff provisions regarding, rolling outages, there's tariff provisions about how and when you can turn people off or do voltage reductions. If it's a reliability issue, you guys are limited under DRS to only reduce down up to 6 hours, right? 2-3 hour calls under DRS within a day's period.
Within a day's period, yes.
Okay. Long term, what's your perspective on carrying enough generation to cover curtailable load?
When you say carrying, you mean?
Owning, contracting, having the right to capacity that can produce energy. And I'll give you greater context and sort of try to ask the question again so that you can provide a helpful answer. You made a comment earlier, and I'm paraphrasing here, that, and it's pretty close, because I just couldn't write fast enough, that you only have to carry, DRS allows you to only have to carry enough capacity, or own enough capacity, or have enough capacity, I think is the term you used, to meet your firm demand.
That's right.
Okay. So what's your perspective on the company's obligations, planning obligations, or
operations obligations, long-term, not just right this second, not 2 years, but 10 years, 15 years, on having enough capacity to serve the entirety of demand at peak, not just firm demand?
It's a very complex question. I mean, even if I had an opinion on it, I'm not an expert in integrated resource planning. And I'd really like to have our experts weigh in on something like that without positing something that's not accurate.
Yeah, and I don't even ask you from the planning perspective, like loss of load purposes or anything like that. I'm asking you from the perspective of, it's your statement, and you kind of indicated that you remember saying it, about you're only required to have enough capacity to meet firm demand. I don't know, my experience looking back at old cases and not having a hobby for a handful of years, being able to go do that I remember that over any long period of time, that the commission made some distinction for our vertically integrated utilities, that they only had to have capacity to meet their interruptible demand, and that utilities could have customers that had a gigawatt of demand or 100 megawatts of demand, and they were only required to carry enough for firm, and that interruptible contracts effectively meant the utility didn't need enough generation to cover that amount of interruptible demand. But it sounds like your perspective is that long-term, you were only required, but effectively what you said, that you're only required, the company is only required to have enough generation to cover the amount of firm requirements, not interruptible requirements. And I just want to make sure that big picture, that's consistent with the company's perspective and sort of how you all plan on addressing that and following through on that on a regulatory front over time.
Well, as a member of PJM, those are the requirements at PJM, is that to have a compliant FRR plan, you only need to have enough capacity, firm capacity, plus reserve margin to cover that firm load. That's the PJM requirement, so we're compliant with that.
Okay, so I'm trying to think of a way to ask you this without Ms. Glass thinking I'm asking you for a legal conclusion. Are you aware of any order from this commission that said that upon joining PJM, that you should plan your system exclusively to meet PJM rules rather than your regulatory obligations under Kentucky state law?
I'm not aware of an order like that, no.
Why is the current EDR limited in the number of megawatts that can be applied under it?
Well, it was created before I came to Kentucky. It's my recollection that it was in relation to how much long we were when we had the Rockport UPA.
Okay. What was the rationale for proposing there to be a cap, but an increased cap, when you all made that filing in 22-181?
Well, at the time, we were getting a lot of prospects, right? Not only EBON, but a lot of other, crypto projects, as well as, more traditional manufacturing projects. And we thought, this is an opportunity that we haven't had in a long time at Eastern Kentucky, and we need the ability to offer these kind of a discounted rates in order to attract these customers. It's just essential to economic development to be able to do that. Absent that, we don't have a game, right? We can't play.
Okay,
And-
but that's a reason to raise the cap. My question is, why even have a cap?
I wasn't around when they put that in place, so.
No, but you proposed a cap at 550 megawatts, so why a cap?
I guess we were thinking that limiting it to that, I mean, we'd see how it went, right? Instead of just unlimited.
What do you, I don't understand. Could you explain to me what would be the benefit gained from seeing how it went?
Well, not all these projects come to fruition, right? It takes time to put these together, and Witness Clark can tell you that, it's a long process for economic development to get a project to come through. So it didn't seem appropriate to just eliminate the cap, to rather calculate something that we thought was reasonable and propose that cap in that case.
Is there a risk to not having a cap?
I'm not sure. I'd think through that.
I think one of my final questions, with regards to the where we started, going back to where we started for a second, the EDR terms and service regarding the dollar for dollar reduction to the IBDD for the capacity purchases when the company has insufficient generating capacity. I'm trying to use the exact term from the tariff. We saw those two paragraphs of the cyber innovation and the development AI, I think is the other name, those contracts.
Mm-hmm.
Is there the same term in this contract?
Not to my knowledge, no.
Okay. Last line of questioning on transmission expense. You were around for the 2020 rate case, right?
Yes,
You're generally aware of the case record in the 2017 rate case?
very generally.
Yeah. I mean, in the sense you probably reviewed it, helping work on the 2020 rate case, right?
Yeah.
But relevant in both of those rate cases was PJM LSE OAT expenses. Would you agree?
Mm-hmm.
Okay. And in 2017, the commission approved a non-unanimous settlement allowing the company to track 80% of the incremental or decremental base PJM LSE OAT expenses through tariff PPA, correct?
Yes.
And in the 2020 rate case, subject to a couple of conditions, including that the company go out and look at ways to control that factor or do something about it, granted the company's request to track 100% of PJM LSE OAT expenses through tariff PPA, correct?
Correct.
Do you remember seeing the testimony, the rebuttal testimony, or the settlement testimony generally in the 2017 rate case on PJM LSE OAT expenses?
I don't.
Okay.
It's
Do you
been too
remember
long.
ever seeing a term in the 2020 case with Witness Vaughn where at the time, this was pre-COVID, pre-energy, 2022, 2021 energy price spikes, but that Mr. Vaughn said in his direct testimony in the 2020 rate case that the PJM LSE OAT expenses were the largest growing expense that the company had, that fuel costs were more expensive at the time we're not growing. Do you remember that generally?
I'll take your word for it. I honestly don't remember that specific comment.
Okay. And then Mr. Satterwhite, just tell me if you remember the testimony from Mr. Satterwhite in support of the settlement in the 2017 rate case, where throughout his testimony on the stand, his direct, his rebuttal, and his settlement testimony, that he basically noted without the ability to track PJM LSE OAT expense through tariff PPA, that the company would be effectively forced to file historic rate cases every single year. because of the growing nature of those allocated transmission expenses. Or were you generally aware of that?
I was generally aware, yes.
Okay, so you've reviewed the testimony in this case, right?
In the Ebon case?
This
Yeah.
case, yeah. And are you aware that the transmission expenses under the economic analyses are expected to increase 5% a year? Did you see the critique of that assumption in Mr. Barron's testimony?
I did, yes.
Okay. If the transmission expenses are only anticipated to be tracked 5% a year, would that force the company in and of itself to file annual rate cases to recover that cost?
Well, the decision to file a rate case wouldn't be based solely on transmission costs. There would be a lot of other costs that we would have to look at in the whole context of filing a rate case.
Okay. You agreed with me, that's what Mr. Satterwhite said about that very specific cost, that in and of itself, it would effectively cause the company to file annual rate increases because of the magnitude of the annual increases of transmission costs being allocated to Kentucky Power.
In general, I believe that is what Mr. Satterwhite said, yes.
You'd be surprised going forward if any single cost increase of 5% a year, in and of itself, drove the company to file annual rate increases.
Would I be surprised if any one particular
Yep.
cost?
If the only difference between 1 year and the next year, except fuel costs, let's just forget fuel costs for a second, any other expense that the company incurs, if everything else stayed constant, do you have any expenses that if increased 5% a year, that increase alone would require you to file a rate case?
I'm not sure. I'd have to look at them and look at the magnitude of them.
Well, the magnitude would be 5%.
Well, 5% of $5 isn't much, but 5% of a larger number is. And that's
That's
my
right.
point, is I'd have to look at the numbers.
Okay, so you know what your transmission cost allocation is. You know what your transmission bill is every single year, right?
In general, yes.
Let me ask you this question. Would 5% be more, less, or in line with the increase in transmission costs being allocated to Kentucky Power since you've been at Kentucky Power?
It was an assumption that we used in our marginal cost. I'd have to go back and look and see. I believe that, I'd have to go back and look. I'm not sure.
You're not sure of what?
Your question was, I think, did I think that the 5% was in line with historic? And I'm saying that I'd have to go back and look at the history on it. I don't have it in front of me, and
Well, you said you reviewed Mr. Barron's testimony, and Mr. Barron specifically averaged the last 6 years of cost increases for transmission expense. And I believe his testimony will speak for itself. I think it was in the neighborhood of 12%.
I agree. Mr. Barron used a higher number. And, you know, in this kind of analysis, we could have a hearing for a month and talk about all the different inputs we could put into a marginal cost analysis. And at the end of the day, mine might be right, yours might be right, his might be right, and the reality is none of them are right because they're all speculative.
Well, but the reality is that under this construct, customers bear the risk that it's wrong. So it's reasonable for us to ask questions about the analysis, correct?
It's absolutely reasonable. I'm just saying that at some point, you have to pick something that is a reasonable number and go with it.
Yeah, and the question I'm asking you specifically is 5% a reasonable assumption based off your experience of receiving effectively every year the transmission bill for Kentucky Power?
It's as reasonable as any other number that we could have chosen.
Okay. So are you generally aware that AEP is a publicly traded company?
Yes.
Okay. And that publicly traded companies ordinarily, although I don't think they're necessarily required to, but ordinarily provide quarterly earnings reports?
I know Kentucky Power provides a quarterly earnings report.
Well, AEP provides a quarterly earnings report, right?
They do, yeah, the Q3s.
And then they do presentations after that, right, with their 10 Qs?
Yes.
Yes.
You're right.
And it's a slideshow presentation where they walk through their earnings of that quarter and they talk about regulatory updates and things like, are you generally aware of that process?
Yes.
Okay, would you be surprised in the last quarterly earning for 1Q of 2023 that the 2023 to 2027 capital forecast of AEP is a 7.6% compound annual growth rate in rate base?
If that's what it says, I don't remember looking at it.
Would you be surprised if that's the amount?
I would not be surprised.
Okay, and so assuming that transmission is allocated at a relative, a consistent amount over that time period of total capital, that, assuming it's just being provided the ordinary amount of capital, transmission would be allocated 7.6% increases.
Subject to check, yes.
Okay, so if AEP itself, if Ms. Sloat expects to increase rate base over the next 5 years by 7.6%, and assuming that transmission gets its fair proportional 7.6% of that, and even if Kentucky Power is being allocated an exact amount, not even this interesting allocation it's gotten for the last 5 to 7 years, just its 7.6% portion of that rate base increase, would you agree that that is in excess of the 5% that is assumed in the analysis?
I can certainly agree that 7.6 is greater than 5.
Okay, and then the final question on this. You said you read Mr. Barron's testimony. You saw the 12% average transmission over the last 6
Yes.
years. Did you go and look at whether or not that 12% average over 6 years was accurate?
I don't recall. I think so, but I don't recall exactly.
And I'll ask you a more fair question. Do you have any personal knowledge that the amount that he cited was inaccurate?
I do not.
Mr. West, I've elevated attorneys and now I'm gonna degrade us. When I say last question, you should know by now. I don't mean to lie, it's just the last thing.
I was hopeful,
Yeah,
Mr. Chairman.
that, this is the last question, but insofar as the allocation of transmission, the increase in transmission expense is in excess of 5%, what does that do to the resulting economic analysis that the company conducted under this agreement? Directionally, at least.
Directionally, it would reduce the benefit, but not below 0. There would still be benefits.
Okay. All right. I appreciate it, Mr. West. Thank you for bearing with me. Ms. Glass, do you have a redirect for Mr. West?
Yes, I do.
Please proceed.
Mr. West, I'm gonna go back a ways to when Mr. Kurtz was cross-examining you. Do you recall maybe 1 or 2 times when Mr. Kurtz insinuated that the company doesn't have enough energy to serve its current customers?
Yes.
Do you agree with that statement? That the company doesn't have enough energy to serve its current customers?
I do not agree with it. The company has enough energy to serve its customers, just like it has enough capacity, whether it's contracted capacity, owned capacity, or as a member of PJM, we purchase our energy from PJM.
Do you have any reason to believe that serving a customer like Ebon would be a problem for the company as far as providing or supplying energy to them?
I do not have a concern with that, no.
Are you aware of whether the company's ever had a supply-related outage where it's been unable to serve its customers?
I am not aware of one.
Would you agree that Kentucky Power has an obligation to serve Ebon?
I would.
It has an obligation to serve Ebon like it has an obligation to serve any customer that requests service, correct?
That is correct.
And so when a customer comes to Kentucky Power and wants to take service, the company can offer its tariff rates, and those are the rates that it's required to offer a customer, correct?
That's correct.
But in certain instances, the commission's regulations allow, and I'm understanding you're not an attorney, but it is your understanding that the commission's regulations allow for terms that vary from tariff rates via special contracts, correct?
Yes.
So the company could have signed Ebon up to take service at full tariff IGS rates, but it instead chose to offer a special contract, correct?
That's correct.
And special contracts generally, including EDR contracts, provide a discount to tariff rates.
Yes, they do.
But this special contract with EBON does two things. It provides discounts in order to secure EBON to the service territory and provide all the economic development benefits that come with it. And it allows the company to get EBON to agree to interrupt 90% of its load under Rider DRS, correct?
That's right. The Rider DRS part was very critical to this contract.
But also so were the discounts, so that
They were.
the company could attract EBON, which would bring substantial economic development benefits to the service territory.
That's right. As I mentioned a few minutes ago, without those, the ability to do that, we're not in the game.
And so EBON locating in the service territory would also bring 250 megawatts of load to the service territory, correct?
Yes,
And the effect of bringing that load is that it spreads Kentucky Power's fixed costs over a greater load, which has the effect of reducing costs for all customers, correct?
that is correct.
And all of these things that we've talked about, that the special contract enables, these are all benefits to the company and to the company's customers, correct?
They are.
There's been a lot of discussion today about the company's participation in PJM, the company's 5 coincident peaks, its 12 coincident peaks, et cetera. Would you consider yourself a subject matter expert on the company's participation in PJM?
I would not. I have a very general understanding of it.
And you rely on experts that either are at Kentucky Power or within AEP Service Corps to provide expertise in that field, correct?
Yes, I do.
So your answers with respect to the inner workings of PJM, its 5 CP events, the effect on the company's peaks, or costs allocated to it are based on your working knowledge and what you understand here today in the context of this hearing, correct?
Correct.
All right. I'd like to go back to the discussion of whether EDR, or not, I'm not gonna call it EDR because it's not, whether the discounts offered in the special contract, whether the company is able to claw those back. I'd like to talk about that. So, as you said earlier, the company's spoken with EBON about whether it'd be willing to amend the special contract to provide for the discount clawbacks identical to those contained in tariff EDR, correct?
Yes.
Okay. And is it your understanding, I'm gonna read a provision of tariff EDR, and I wanna know if it's your understanding that this is the provision that EBON would agree to. The customer may discontinue service under this rider before the end of the contract or agreement addendum only by reimbursing the company for any and all demand reductions received under this rider when billed at the applicable tariff schedule rate. Is that the provision that you understand EBON will agree to?
Yes.
Okay. And I'll state for the record that that is on tariff sheet 37-5. Have you spoken to EBON with, about what kind of timeline or when they might be able to execute such an addendum to the contract that would reflect that agreement?
Yes. EBON indicated to me that they could execute such a document on Monday, and we could file it in the record on Tuesday of next week.
I don't have further redirect, but, Your Honor, I would like to request on behalf of the company an additional opportunity outside of this proceeding to fully address the issue with respect to the Discover AI and cyber innovation contracts, to understand what issues the commission might be considering with respect to that issue and the IBDD and SBDD
Yeah,
credits.
my recommendation would be that if you all, that would be best taken care of maybe in a request for declaratory order.
Okay. Okay.
Given the, I guess the additional information gleaned from some of Mr. West's questions, including the language that was just discussed there at the end about an addendum to the contract, I'm gonna go back through and see if anybody else has any additional questions for Mr. West before we ask them to stand down. Mr. Kurtz?
No, Your Honor.
Mr. West? No? Vice Chair? All right, thank you very much, Mr. West. Ms. Glass, at your convenience?
The company calls Amanda Clark.
Either one.
Okay.
As long as your
Didn't
hand
know
goes
if I
up, it
needed
doesn't
to
matter what
stand
you're
for the
standing.
oath.
All right, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct and according to your perjury?
I do.
Please state your name and business address for the record.
Thank you. My name is Amanda Clark. I'm the External Affairs Manager for Kentucky Power at 1645 Winchester Avenue, Ashland, Kentucky.
Ms. Glass, you may ask.
Thank you. Ms. Clark, did you cause to be filed into the record of this case rebuttal testimony and responses to data requests?
Yes.
Do you have any corrections or modifications to either of those?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
The witness is available for cross-examination.
Mr. Kurtz?
Thank you, Your Honor. Just 1 second. I thought the other witness was going first. Okay. Good afternoon, Ms. Clark.
Hello.
You're aware that the contract refers to 50 to 100 jobs?
I do.
Okay. And that the discovery response is 115 jobs,
Yes, sir.
and your analysis assumed 125 jobs?
Yes, sir.
Okay. Is there any guarantee that any of those jobs will actually be created?
I am not employed by EBON, and so I can't speak to their ultimate whether they do or they don't, but it is their plan to create between 100 and 125 jobs for the project. The reason for the discrepancy in what started in the contract and what ended up in discovery and then in rebuttal testimony is the amount of time that we've been having this conversation. We started talks with EBON 2 years ago, and at that time it was a 100-megawatt project. And typically what we've seen in the crypto industry is about a half a job per megawatt. So every 2 megawatts yields a full-time position. That's pretty standard in the industry. So at 100 megawatts, we were at 50 jobs. And as we've worked through this process, and because of EBON's commitment to the service territory and to this project, the project has actually expanded into 250 megawatts and thus the additional jobs.
Well, the contract is for 250 megawatts, right?
Yes.
Yet the contract says 50 to 100 jobs. So this growing is already reflected in the contract.
I truly don't have an answer for that. I'm sorry. I don't know if it was through the negotiation that it became that way.
Well, you're promoting economic development is a big reason to approve this contract, yet there's no guarantee that those jobs will appear, and there's no penalty if they don't.
There's not usually a guarantee that any job will materialize from an economic development project that's announced at any level for any kind of project.
Oh, are you sure? Aren't there provisions where if a company gets an economic development deal from the state and they don't produce, they have to give some of it back?
All of the economic development incentives from the state of Kentucky are performance-based. So if a company announces 1,000 jobs, those incentives are announced based on those 1,000 jobs. What they actually get from the Commonwealth is based on the number of jobs they actually create.
And that's not the case here. EBON will get the exact same economic discounts whether they create 125, 115, 100, or 50 jobs.
That is correct.
So that's different than what the state of Kentucky does.
Correct.
So this would not be performance-based.
Absent the discounts for their economic development benefits, they would not be here. So we felt it necessary to offer those.
Performance-based sounds like a good idea. Did you consider that?
That would have to be a conversation with Ebon that we haven't had.
Okay. Were you in, this idea about filing an addendum next week, were you involved in any of those discussions?
Yes,
Okay. You heard the discussions about the counterparty to the contract being a limited liability company.
yes, sir.
So was there any discussion about any kind of parental guarantee to stand behind that clawback?
Not to my knowledge.
Well, what good, I mean, I don't want to be, isn't a clawback of limited value if the counterparty doesn't have any money?
I would assume so.
Chairman, I'd like to have this marked as KIUC 6.
Thank you.
This is a non-confidential, confidential.
Correct. Yes, non-confidential.
Okay, some of this we've
Just said marked as KIUC 6.
Thank you, Your Honor. Sorry. Page 1 is the first page of the contract. Page 2 is just simply the 50 to 100 jobs. We skip that. Okay, page 3 of this handout. This is a section from your rebuttal testimony. Private sector company, Ebon, bringing up to 125 jobs at higher than average wage to diversify the economy and generate tax revenue is the very definition of economic development. The median household income in Lawrence County was $29,167 in 2020. Ebon's planned wages will range from $44,000 to $77,000. Did I read that right?
Yes, sir.
Okay, and your footnote 8 refers to Mr. West's testimony?
Yes.
Okay. Page 4 of this handout is the discovery. You were here when Mr. West and I discussed this very document, correct?
Mm-hmm.
So you heard the testimony that in phase 1, 39 jobs would be at $18 an hour or less.
Yes, sir.
Okay. Then phase 2, you would add 52 jobs at $18 an hour or less, correct?
Yes.
Okay, so 79% of the jobs would be at $18 or less?
I would agree with that calculation. I'd have to check.
Well, then how do you square this on your rebuttal testimony that the planned wages will range from $44,000 to $77,000?
I'm not sure the answer to that.
Okay. Back on page 4 of the handout, the total payroll is $5.3 million at the end of phase 2?
Yes.
Okay. Page 5 of the handout is also from your rebuttal testimony. And now you've increased the jobs to 125, and you've increased the payroll from 5.3 million to 8 million. This is how did that happen?
So table one is from the in-plan model, which analyzes 528 sectors and all of the benefits associated with that job in the territory. So yes, it's 125 jobs, and the number increased from 5 million to 8 million because that also includes their benefits.
Okay, so you input the 125 and in-plan, that was the input and the output is the in-plan 8 million?
Yes.
Okay. So that would indicate a benefit to wage ratio of over 30%, correct?
I don't have a calculator in front of me, but I would, if you say so.
Do you think that these, what kind of benefits, somebody earning $18 an hour, what kind of benefits do they get to increase their package by, in the 30% range?
It would be a full-time job, so they would have health insurance benefits, there's workers' comp, there's all the benefits that are associated with a full-time position.
Did in-plan spit that out?
In-plan spits that out, yes.
Okay. EBON did not say that that's true. The computer model spit it out.
Correct.
Okay. Okay, the next page of the handout is the $250 million of CapEx.
Yes.
Okay. Now, we know on page 7 of this handout that 165 million of the 250 are computers. Correct?
Correct.
Okay, let me back up. The in-plan model, you input, you pick a category, and there is no there is no cryptocurrency mining, so you picked what you thought was the closest, data processing.
I did not create the tables.
All right, but you chose the industry grouping as data processing. You chose that as the in-plan industry. You didn't choose steel or aluminum, you chose...
Correct, it's modeled after the industry, yes.
So, but there is no crypto mining in-plan data set, so you chose...
I don't know that to be true. Like I said, this was done through Service Corps based on the industry.
Okay. And so for the capital, you input $250 million, and then in-plan isn't looking at the EBON situation in particular, it's looking at a generic industry standard, and it just spits out how much of that $250 million is going to be assumed to be locally related, because that's what you're looking at, the 20 counties, right?
Yes.
Okay. So the computer model takes the generic $250 million investment and says, aha, based upon a generic model, we think, this is on page 9, 81,093,173, 81 million will be locally related. That's the local effect from the in-plan output, page 9 of this handout.
Yes.
But we know that 165 million of the 250 is definitely not local. These are computers not produced in the 20 counties in eastern Kentucky. These are from the home company, correct?
As far as I know.
And then I was looking at these pictures, these containers, these 250 containers, none of those are produced in the 20 eastern Kentucky counties.
I don't know the answer to that. There is a container producer within our service territory, but I don't know where EBON is planning on getting their containers.
Well, that would be important, because if they're not buying them from a local producer, then this should not be in the local economic impact.
I'm not sure where they're getting their containers.
Okay.
So it's possible that it could be in the local impact.
The other thing that looked big was the $10 million substation. That's not being manufactured in eastern Kentucky, is it?
It's being built in eastern Kentucky.
But it's not manufactured.
I don't know if, no, we don't manufacture transformers and electric components in eastern Kentucky.
So what you've done is you've taken a generic, every 2 megawatts equals 1 job, so 250 megawatts equals 125 jobs. You've taken EBON's estimate of a $250 million investment.
you put that into the generic computer model, and it spits out what the generic answer would be, correct?
It is a computer model.
Okay. So it's not an EBON-specific analysis,
It is specific to the industry in which EBON is involved.
but it's not EBON-specific. You
Not
didn't
necessarily.
adjust the model for any,
Like I said, I didn't create the model, and so I'm not sure how to adjust the model specific to a particular company.
you know, I've worked with a lot of, well, a couple of experts, Paul Coombs, Barry Kornstein, who use this model, and they do adjust it for individual specific characteristics instead of just using the generic to be more accurate. Is that something you considered?
I did not create the M-Plan model. We have staff that does that, that's an expert on that, and is an expert in M-Plan. I'm not. And so we gave him the parameters, and he gave this back to us.
If Mr. Barron's testimony is correct, that this contract will result in increased rates for consumers, that would have a negative impact on the economy, correct? People would have less money in their pocket to spend on the restaurants and so forth that you talk about in your testimony.
One thing is certain, without the jobs in the territory, that will have a very negative effect on the local economy.
Well, won't a rate increase resulting from the contract have a negative effect on the economy also?
I can't speak to a rate increase in hypotheticals. I'm not part of that process either.
Okay, but if Mr. Barron's analysis is correct, that this contract will result in higher costs for consumers, that would be a negative.
I would agree with that.
And that was not factored into the in-plan analysis?
Not to my knowledge.
Thank you, Chairman.
I think we agreed on you going next, Mr. West. Please
Yeah, I don't
proceed.
have any questions.
Okay, well, even easier, Mr. Smart.
Thank you, Your Honor. Good afternoon, Ms. Clerk.
Hello.
Could I start by asking you to describe your personal role and involvement with EBON? How long have you been involved from the very beginning, or have you been the lead person talking with them?
Yes. Yes. So the way that all of this came about is after the Kentucky legislature passed House Bill 230 and Senate Bill 255, there were numerous cryptocurrency inquiries in Eastern Kentucky Kentucky Power service territory. Because Kentucky Power is unique in the fact that we do have stranded assets in terms of abandoned coal facilities, those sorts of things, there's infrastructure on the ground that was attractive to the crypto companies. So I've, over the course of July to October of 21, probably fielded about 200 calls, 200 inquiries for crypto companies all across our service territory. And EBON was actually one of those. Most of those conversations ended when I could not guarantee 3-cent power for a gigawatt of power tomorrow. They wanted power very cheaply and very quickly, and I couldn't guarantee that for those companies, and they just went away. We didn't hear from them. In terms of, I think you mentioned earlier the process about the crypto process and all of that. I developed that process and that questionnaire in order to deal with all of these inquiries. And although you didn't ask, I'll tell you, there is not a form for EBON because the form was developed after we'd already started talking with EBON. So EBON was sort of one of the first up in terms of companies that stuck around after the initial conversations. And again, those began in August of 2021, so this has been going on for 2 years. I have been sort of the liaison between EBON and any of the applicable departments within Kentucky Power and AEP. I'm just sort of the go-between, and I make sure that EBON gets to whoever it is they need to talk to in whatever capacity in the company. It doesn't mean that I negotiate every part of this process. I just make sure that those happen.
Thank you, that was very helpful.
You're welcome.
So what is the current status of the EBON project?
The current status of the EBON project is everything is on hold until we figure out this contract. EBON cannot move forward until they know if they're able to get power that makes sense for their model.
And so have they begun undertaking any steps to begin constructing the facility?
What they have done is, so there's several components to this facility. First of all, there has to be the upgrade to the station that's on our side. They have committed funds and actually paid AEP to do pre-engineering to upgrade that station to meet their needs. They have also worked with our Associative Business Development Group to begin the engineering of the 250 megawatt station on their side of the fence. So there's our station that will serve their station, and then there's a distribution network that will take that power all around their portion of the leased property. And so quite a bit of work has been done on the engineering side to get ready to be able to build the facilities that will take the power.
Have they hired anyone to work at the facility?
I don't know.
Have they made any capital expenditures, to your knowledge, to begin constructing the facility?
I don't know the answer to that either.
Have they contracted with any construction companies to build the facility?
I'm not sure. I know that I was part of a meeting between them and the Lawrence County Fiscal Court where Lawrence County was identifying local contractors. I shouldn't say fiscal court, the judge and the deputy judge, identifying local contractors for them to reach out to. I know that the site's going to need quite a bit of gravel, and they've been working with people on that. And also in terms of hiring, they have worked with East Kentucky Concentrated Employment to develop the job descriptions and the pay scales for the positions that were posted in the discovery.
Do you know if EBON has any other facilities in the U.S. currently?
I know that they have offices in New Jersey, but beyond that, I'm unaware of anything else.
Are you aware if they have any assets in the United
I
States?
have no idea.
Could you turn to the response to AGKIUC 1-19?
Yes, sir.
Are you there?
Mm-hmm.
And so you were just referencing Eastern Kentucky Concentrated Employment, right?
Yes.
And these are the job descriptions you were referencing?
Yes.
And attached to the discovery response, there's a flyer.
Mm-hmm.
So other than collaborating on the job descriptions and sending out a flyer, do you know if Eastern Kentucky Concentrated Employment has done anything to help with local recruitment efforts?
I don't know the details of their relationship, but I do know that because the project has been effectively put on hold while we wait for this contract, I don't know that any hiring, job fairs or anything like that have gone on. We've been very, very careful in Kentucky Power, in Lawrence County, and especially with EKSEP, not to do a great deal of fanfare about this project because, you know, people get excited about 125 jobs, and the last thing that we wanted to do was announce another project in Eastern Kentucky that we weren't fully aware would go, and since it's dependent on this contract, we've held off on making a big push about it. I suspect once we do, or once we are able to make an announcement, the website and EKSEP will be much more active.
Have you ever visited the website that's referenced in the flyer, or there's a QR code here too, right? That's also links to their website?
I think at one time I did, yes.
Do you know where the QR code takes you?
I do not.
Well, if you scroll down to so this would be attachment 2, starting on page 2 of attachment 2, it lists out the job descriptions, is that
Yes.
right?
Mm-hmm.
And within each of those job descriptions, it states that the positions will be located in the United States, is that right?
Yes.
The job descriptions don't mention Kentucky specifically, do they?
They do not, because we've not made an official announcement about the project.
And if you were to go to the website that's linked in the QR code, there'd be no mention of Kentucky either, right?
No, sir.
And so your testimony is that this is because there hasn't been an official announcement, so that's why there's no information on
Correct.
eBank's website about the Lawrence County proposed facility?
Yes, sir.
Has Kentucky Power requested any commitments that EBON's jobs would stem from the local community and not be remote?
EBON has indicated on numerous occasions that they do not intend to hire remote workers, that all of the positions will be located on-site at the Big Sandy facility.
Is that a commitment in the contract?
I don't know if it's in the contract or not. I don't believe that it is.
Has Kentucky Power taken any steps to verify EBON's claim that they would be bringing 100 or more jobs to the site?
Not beyond just, like I said, standard industry practice.
Could you refer to the response to Joint Interveners 2-1?
Yes, sir.
And this is in part where you talk about the standard industry practice, right?
Mm-hmm.
But could you also take a look at subpart B? The response there reads that the company relies on information provided from potential customers to present accurate job projections. Is that
Yes.
right? So that basically means that you're just taking what the company says as true.
Yes, we really don't have any other recourse.
And the numbers that have been cited, 50, 100, 125, what evidence has EBON provided to support that this will be the number of jobs that will be created at this site?
Again, that's what they have conveyed to us. The list of positions that they've been working with EKSEP to fill, all of those are indicative of that number.
If you look at the list, and Mr. Kurtz helpfully passed out a copy of it, this was an attachment to, looks like JI 1-6. For the higher salary jobs on that list, those wouldn't necessarily need to be located at the facility, right?
EBON has indicated that they will be.
But a job like a computer networking or software job, in today's world, those are often done remotely, is that right?
I assume it depends on the business model, and as I mentioned, EBON has said that all of the positions will be located on site. That is their intention.
Have they said that in writing?
I'm not sure. I would have to check the correspondence that we have in the discovery about their model and why they're here, their letter that they sent. I don't know if it's in there or not.
But if it did exist, it would already be in the record, is that?
Yes, sir.
Your position? Thank you. Could you turn to, we were looking at a map earlier of the site, which was attached to PSC 1-2. Do you recall, were you here in the room for that
I don't have that in my book.
testimony? You don't have it with you?
It's not out, that was not my, my response, so it's not in my book.
Would we be able to, do you have a copy that you could provide the witness of the discovery response? It would have been in Mr. West's binder.
I have an electronic copy with me, so I think we do have a paper copy.
Thank you. Appreciate it.
Thank you, Brian.
1-2. The map. I think it's PSC 1-2. Thank you. I'll give this back in a minute. Yes, sir.
So I was asking questions of Mr. West earlier about this map and whether it was a complete representation of the proposed facility. Were you in the room for that?
Yes, I was.
Do you know the answer to that question?
Are you talking about page 2 of 2?
Yes.
No, this is not a complete representation of the facility. To my understanding, this is a drawing that locates where the power components of this need to be. So you notice on there, there's the generating station, there's the customer substation, and so they laid out the containers to make sure that they would fit on the property in relation to the station that the customer is going to build.
So are there buildings that are being planned that are not reflected in the drawings?
I do not know that. I don't believe so. But this is not, this is just the drawing of the containers and the customer substation that they will construct.
Do you know if EBON's planning to build office building at the site?
I'm not sure. I would assume so.
You would assume so, but you're not aware of any specific?
I'm not aware of a specific building. There are 2 buildings located on site that are included in their lease. I don't know if they intend to use that for office space. Like I said, I'm not an EBON employee.
What are the buildings that are included in their lease?
There are 2 warehouses on site.
Are they reflected in this map here, the attachment to 1-2?
Yes.
Are you aware of whether EBON is intending to build a parking lot at the site?
I'm not aware. Like Mr. West, I assume there will be a place for the employees to park.
But you don't have any evidence that they have plans to build offices for 125 employees or a parking lot?
No, sir.
The EBON facility is planned for 24-hour operation, is that right?
Yes.
Do you know, is there plans to have lighting installed around the containers at the site?
I know that there is a plan for electricity to be distributed all around the site. I would assume that would include lighting as well.
I believe Mr. West testified earlier that you were involved in negotiations around the lease of the property. Is that true?
I, again, facilitated those conversations. I did not negotiate the lease. Our real estate management group did that.
And the terms of the lease are confidential, so to the extent that there are any questions about the terms of that lease, we would need to go into confidential session.
Thank you. Yeah, thank you for pointing that out. I don't intend to ask about the terms of the lease, but it's good to,
Okay, thank you.
please let me know if I steer in that direction. So there was a supplemental response to joint interveners request 1-8 concerning the lease. Are you familiar with that?
Let me see. Yes.
And that supplemental response said that any rent received by Kentucky Power pursuant to the lease would be credited to an account that would be included in the retail cost of service, is that right?
Yes,
So does that mean that any revenue received by the company through the lease would benefit ratepayers?
yes,
And conversely, if the company failed to maximize the revenue that it could receive through the lease of the property, that would adversely affect ratepayers, correct?
yes,
Because the company would be leaving money on the table that they could otherwise have gotten through the lease.
yes,
Is that correct?
yes,
And the company is also obligated to cover any property taxes associated with the property after it's leased, correct?
that is correct.
And so if the property taxes go up because of improvements at the site, Kentucky Power is responsible for those increased property taxes, is that
They
right?
would be, yet we have had conversations with the Lawrence County judge who has agreed to take to the fiscal court to abate any increase in the property tax as a result of this contract.
I'm sorry, you've had conversations with the judge, and what has the judge said?
The judge is willing to ask his fiscal court to abate those taxes, abate any tax increase as a result of this contract.
This would be in the future,
Correct.
if there were an increase in property taxes, you've had discussions around whether those could be abated.
Yes, sir.
Is that, has any of that been reduced to writing?
It will not be until there is a contract in place and the fiscal court takes action.
And there's no guarantee the fiscal court would approve that, is that right?
Correct, but we don't believe that there is any reason they wouldn't.
So I'm going to try to ask this question without asking you to reveal anything that's confidential. What consideration did the company give to the potential benefits to ratepayers of the amount of revenue that it could receive from a lease of the property in negotiating with EBON concerning the terms of the lease?
When the company began talking with EBON about leasing this property, the property was in the process of being demolished. Unit 2 was in the process of being demolished. We identified it, like I said, through our process of being a particularly good site for crypto companies because it was in the process of being demolished and because of the nature of the crypto industry. Basically, they can put gravel on the lot, drop the containers, and then there's a viable business on the property. Because the property was in the process of being demolished, it had very little commercial value to anyone outside of this industry. And in order to get it to where it has significant commercial value would be an extensive cost to Kentucky Power that would then be passed on to ratepayers.
Would you agree that this lease is potentially another benefit that Kentucky Power is providing to EBON through this process?
I would. Yes, sir.
you- You turn to response to joint interveners request 2-1.
Yes, sir.
We were talking about this a minute ago. So part of this response was to list out the inquiries that Kentucky Power has received from cryptocurrency companies, is that right?
Mm-hmm.
How many of these companies have actually located in Kentucky Power territory?
To my knowledge, I think 3 of them.
That's all the questions we have. Thank you, Ms.
Thank you.
Staff. Just one question. Earlier in your testimony, we were talking about jobs and the relationship to any sort of discounts that EBON may be receiving. Am I correct in understanding that none of the discounts that will be received for the contract are conditioned upon job creation or maintaining those jobs?
At this point, no.
Okay. That was my only question. Thank you. Question.
Hello, Ms. Clark.
Hello.
Let's get this closer. So earlier I was speaking to Mr. West about all these other contracts that have been hinted toward, but we've not been provided any details on. Are you able to give us more information or some reason to believe that this would lead to a wave of economic development, or that other things are specifically dependent upon this, so that if this contract for some reason is not approved, we're killing economic development across an entire region?
As Mr. West mentioned, there is an additional project associated with EBON, and they don't mind me saying that, associated with EBON, that they would like to put near this facility, just for ease of operation. It is a solar panel manufacturing facility that also has the solar glass manufacturing component. And that project has the potential of a $300 million investment and 1,000 jobs between the two parts of basically one project. We can't locate the project on a single site, so they're looking at a couple of sites still within Kentucky Power service territory. They are engaged with the Cabinet for Economic Development. They're working through that process to correctly identify a site that works best for them. But like I said, they are looking in Kentucky Power service territory to keep those central to each other. If we do not, if they don't end up locating in Louisa, then they are also looking at locations in Georgia, Alabama, and Mississippi for the other component of this, and they would just move everything wherever they end up finding a spot.
So the extent that it would rely upon granting this contract would be more like convenience than needing a power agreement or needing access to substations?
Power is important in the solar manufacturing facility as well, and again, they're looking at sites that have the ability to serve them. Could be between 30 and 60 megawatts, which is not a small project. So that's a large component of it as well.
Right, and again, I know these questions are fairly general, but are you involved in projecting what might be requested in rate cases as far as residential rates?
I'm not.
So would you have any information to add about when residential customers might expect to see an application for rate decrease?
I can't speculate to that. I can only say that and I apologize if I get a little emotional because it is Eastern Kentucky and it is my place, and I want Eastern Kentucky to succeed. My very existence at Kentucky Power, my number one goal is to bring people and load so that we can stabilize rates, stop the bleeding all across Eastern Kentucky. And I don't know how long that takes. I don't know what the threshold is by which we being Kentucky Power say we finally made up what we lost and so now we're in the good. I don't have the mechanism to understand that. What I have been told from just like every other residential customer, if we bring jobs, if we bring load, this will help. And that's like I said, purely what I exist to do for Kentucky Power.
So I know that people in load are important. I know that you know that I've studied this
Yes.
as well for years. But are we achieving a balance in bringing extra people and more load with bringing the right price and feasible capacity with this project?
Because I'm not involved in the rate-making process, and truly, I'm woefully ignorant when it comes to, you need this to get here. Like I said, my job is in economic development and bringing the people and bringing the load. I know that we're not going to make any progress if we don't start somewhere.
That's it. Thank you.
I'm gonna spare everybody and not put them, oh, yeah, I'm sorry, I got ahead of myself, go ahead.
Good afternoon. Just a couple questions. Can you walk me through how Kentucky Power does their due diligence when you're looking at putting something like this together and asking for a special contract?
Due diligence in terms of the company and why we would.
In all areas.
Okay.
I'm assuming if you're looking to do a special contract, that Kentucky Power would do its due diligence for all parts of the company.
So in this case, and I think it's been discussed a couple of times in terms of how we came to the place that we just determined we needed a special contract. With a special contract, we're able to require E-bond to be interruptible, which we think is a benefit to all of the ratepayers, and we've been through all that this morning. The other part of this, in terms of due diligence, for us and real estate and credit and risk and those sorts of things, essentially we give everything that we have and ask the company to give financials and all of those sorts of things to our credit and risk department with AEP. And in terms of this particular project, because E-bond, according to credit and risk, because E-bond is paying for every single piece of this project that it's going to cost to serve them up front. They're building our station up front, they're building their station up front, their distribution, that is all on their cost. Because they're doing all of that up front, credit and risk did not believe that they were a risk to the company in terms of us putting money into a project that wouldn't go. If E-bond went away, they will have upgraded our station to handle another 250 megawatts of load, wherever that comes from. There will also be a 250 megawatt station on their side for whatever happens to come next.
But if E-bond goes away, the ratepayers take the increased pricing for E-bond going away. Am I right about that?
If we're not purchasing power for E-bond, then the other ratepayers wouldn't pay for it, correct?
Okay. When you talked about putting information into the implant, is that right? You did not use cryptocurrency or crypto mining type information. Is that correct?
I am unaware of which sectors that our planning modelists put in there. They knew that it was a crypto model and they outlined those sectors.
And do you know if your planning team looked at other crypto locations, either within E-bond or anybody else doing this crypto mining?
I do not. Like I said, M-Plan is a software model that analyzes, I think, 528 different sectors, and you pick the sector and it does the thing it's made to do.
Okay. I think that's all I have. Thank you.
Thank you.
You been to the Big Sandy site?
Yes, sir.
Okay. There's a 765 kV substation right up the street, right? Up Highway 23. There used to be a Big Sandy 1, or there was a Big Sandy 1 coal facility and it's been converted to gas, right?
Yes.
And there was a Big Sandy 2 facility that has now been retired and demolished, right?
Yes.
I was wanting to know earlier, you were talking about demolition occurring around the time you were initially discussing this with Yvonne. When would that have been?
21 was the end of the demolition. They were finally finishing the site demolition.
Okay. and just
Summer of 21.
Okay, and that's why I wanted, I mean, the cooling towers came down in 16, so the demolition occurred throughout and until 21.
Yes,
And then the coal ash pond, that remediation was finished in 20 or 21, right?
I think so.
About that time?
Yeah.
Roughly, okay. So there's no more construction necessarily going on in the facility, is that
Correct.
right? Okay, great. Have you ever heard the name Greg Pauly?
I have.
Okay. Greg Pauly used to be the president of Kentucky Power, is that right? Okay. I've got an article, because I remember this being discussed around the time, in the middle of 2016, that specifically was discussing Big Sandy. And it's only relevant relative to what I thought I heard your response to Mr. Samar was. And I'll just read the quote and see if it makes sense to you in your current position. The quote is, this is a June 27, 2016 article with WYMT, you know WYMT, right? The flat land at Big Sandy is located between a 4-lane highway and the Big Sandy River. It has not only highway and river access, but also rail. It has the potential to be an ideal industrial park site, and we look forward to pursuing that possibility for the region. Did it have the potential to be an ideal industrial park site?
It did have the potential, and I guess theoretically could have the potential. One of the most important things in site development, or in citing a project for economic development, is site readiness. This site is deficient in its water capacity, in its sewer capacity, in groundwork. And so in order to make it a premier industrial site, there is a significant investment that needs to go into that. Significant. And so when I say it had the potential, I guess one day could have the potential again. In my previous position in a regional economic development organization, we had a flyer on the Big Sandy property, the 83 acres of the Big Sandy property. One East Kentucky had a flyer on the Big Sandy property. We marketed that property and took it everywhere and said, we've got this property that could be available. We've not been successful in locating anything on that site. We've not been successful in any bites on that site, quite frankly. So my statement that it has very little commercial value is because it's not ready. It's just simply not ready. And like I said, in order to get it ready, the owner, AEP, is going to have to put a sizable chunk of money into it, and then that money is going to be passed on to ratepayers.
Yeah, so does AEP own the site or does Kentucky Power?
I don't know the answer to that. I don't know how the system works in terms of property allocation.
Another question for you. In your rebuttal testimony, you discuss, and start at the bottom of 16 going on to 17. And it's along the lines of the questions that Commissioner Regan was asking you. And I'm just using the term was used in your testimony, the contemplated protections for customers. Do you remember that question? Line 15 on page 16?
Yes.
So you discuss, quote, the contemplated protections for customers, and paraphrasing here, in the unlikely event of what I assume to be your reference to Ms. Sherwood's concerns around migrating quickly. Do you remember that?
Mm-hmm.
Okay. And so you note a couple of items here. You noted that the company had already indicated the internal process for vetting cryptocurrency customers.
Yes.
So have you read Mr. West's testimony in this case?
Mm-hmm.
So do you all do an internal process for vetting other potential type of customers?
We do. Same sort of thing. If we have a customer that is requiring upgrades or any of those sorts of things, they would go through credit and risk as well.
Okay, but I guess what I'm trying to figure out, do you all have a special process for cryptocurrency customers?
We have a special process for cryptocurrency customers only in that we were receiving so many requests all at the same time and really had no possible way of determining if the company was real, if they were basically just fishing for rates, any of those sorts of things. So I created a process because what was happening was a potential customer may call me. He may call any of my other external affairs counterparts. He may call any of the economic and business development managers across all of AEP's footprint. He may call every customer service manager across the company. And we had to find a way, we had to develop a process so that those calls and how we handled them were streamlined. Because what we found is all of us were talking to the same people and thinking they were different projects. And that was an anomaly.
Okay. So, you note your internal vetting process. You noted that they would pay we'll call it CIAC, the Contribution Aided Construction. Sorry, here, I wanna get it close. And that they would pay the regulation required 2/12 annual bill as a deposit, right?
Yes.
Then you finally noted that you referred to the company's response to joint interveners data request 1-35 regarding the remedies should they default on the special contract. Is that right?
Yes, sir.
Okay. And you weren't the respondent to 1-35?
I was not.
Interveners, great. But neither was Mr. West, is that right?
I'm not sure who the respondent was.
Well, would you be surprised to find out council was the respondent
Okay.
to 1-35? Okay. Would that surprise you?
It would not.
Okay, so by definition, we don't have the addendum to the contract referencing what was referred to earlier as the clawback provisions yet, right? That's going to be subsequently filed with the commission, right?
Yes.
So by definition, that response could not have covered a provision that did not exist at the time, right?
Correct.
Just circular, I know, but I just want to be clear. And would you agree there's a difference between, generally, there's a difference, well, that's a legal question. Do you feel like, from your perspective, that the response to 1-35 is an important, using your words here, protection contemplated for customers?
Yes.
Okay. And so, the company having an appreciation for those legal remedies, as conveyed to folks like you from council, is an important safeguard for the company and consumers.
I agree.
Is that right?
Yes.
Okay. All right. So I'm gonna, just for a second, Ms. Glass, I didn't identify council, but I'll turn it to you and Mr. Garcia Santana here. I would ask, insofar as the application is updated, or the record is updated with a new proposed contract or an addendum to the contract that has the new provision regarding the clawback of discounts, right? I guess it's technically a rate, but it's not necessarily a prospective rate for service, as it is a payment for a discount already provided. If that changes, your all's response to 1-35, I would ask that you supplement the response following the filing of that addendum or amended contract.
We will certainly do that.
Okay. My other request, and it's not my data request, Mr. Smar may, you can ask whatever he wants, but I think I would like to ask staff on my behalf to ask a post-hearing data request that effectively, how do I say this? Seek some sort of confirmation over the last 5 years how you all have implemented Tariff EDR in terms of whether you all do anything differently for that IBDD or SBDD clawback provision in terms of security any differently than you do prospective, security for ensuring that you're paid for service. Because one, of course, is you already have security against prospective billing at an expected demand, but a discount period that may be 5, 10, 15 years of discounts that you all have to go back and get is just a different matter. So some color on how you all have actually implemented those discounts and any security related to them. We'll put that in writing, of course, but I'll just give you a heads up. That's given the 1-35 and the subsequent expected change to the contract, that would be helpful.
Sure thing.
And that would be, of course, under tariff EDR. So that's,
Correct.
yeah.
Understood.
And maybe this was a Mr. West question that I missed asking him. The 2/12, how often internally would just, 2/12 is your all's, across the board, I mean, it's our regulation that requires or allows, depending on the circumstance, 2/12 deposit. 2/12 is based on their expected billing if it's a prospective customer. Internally, how do you all have, do you know how you all have discussions about if demand increases at any time, or, well, let's just talk about 2022, where power prices tripled or doubled over the time period, which by default increased total bills. We saw that for across all the classes, like tariff PPA, FAC went up. How often do you all recalculate those, and do you do it prospectively based off an expectation that like wholesale prices are gonna go up and therefore we need to increase their 2/12 because we expect, their expected billings are gonna go up? Do you have any insight into that?
I'm not part of that process, so I have no idea.
Do you do this for any other territories? For APCO or any of the other Kentucky Power?
No,
Have you ever
just
done
Kentucky
economic-
Power.
Okay. All right. Ms. Glass, do you have any redirect this witness?
Yes, I do.
Please proceed.
Okay. Ms. Clark, I'm gonna ask you just some general questions,
Okay.
not specifically to what the chairman was just talking about. Earlier, you were talking about how the main objectives for you as part of your job with Kentucky Power are to bring people and jobs, correct?
Yes, ma'am.
So would you say your sole job or your number one job is economic development for Kentucky Power?
It is.
And are discounted rates a significant tool that you have to bring these types of customers like Ebon to the service territory?
Discounted rates is just about the only tool that I have from Kentucky Power to bring businesses to the service territory.
And it's your understanding, I know you have nothing to do with the rates, but the company is able to offer those discounted rates through special contracts and through EDR contracts, correct?
Correct.
Just generally, would you say that economic development is more important to Kentucky Power service territory than perhaps other utility companies in Kentucky?
I agree with that statement. Kentucky Power service territory is about 30 years behind in the economic development game. And I say that just sort of in context. I guess I got too close to the mic, I'm sorry. I say that if you think about, like, Greater Louisville has been involved in economic development activities since like 1987. And so they've kind of got a 30-year head start on getting sites ready, preparing a workforce, all of the things that are important in economic development. We're behind, significantly behind. One East Kentucky's been in existence for 6 years, 7 years. And so for Kentucky Power, who's lost 11,000 customers over the last 15 years, and quite a significant amount of load. The only way that we're going to stabilize rates and the only way that we're going to dig ourselves out of this is through economic development. We must bring companies, we must increase the load.
Can you put into perspective, based on your position, you know, your sole job being economic development for Kentucky Power and all of your experience, can you put into perspective how big of an opportunity for economic development the prospect of the EBON facility locating here is for Eastern Kentucky?
It's between 100 and 125 jobs, and that's massive. I think I was looking on the Kentucky Cabinet for Economic Development website to see if I could find the last project announced in Lawrence County, and I think it was 2008, and it was 38 jobs. And so Lawrence County is over the moon at the prospect of 100 to 125 jobs. It's a big deal. There was some mention this morning about how an $18 an hour job is not that important. Right now in Lawrence County, the annual household income, the median household income is $29,000, which is a little more than $14 an hour. $18 an hour is significant. And especially since some of those, or a lot of those $18 an hour jobs are unskilled positions that EBON is going to train on site. We're going to be able to take the unskilled and put them to work, which is an opportunity that we don't get every day in Eastern Kentucky. So I guess to more directly answer your question, is it a big deal? It's a massive deal to win 100 to 125 jobs in Eastern Kentucky.
And you've also heard talk about today, and you've talked about the possibility that EBON could have another project that would bring even further development, correct?
Correct.
Can you talk about what effect that there would be to the service territory or to Kentucky Power's other customers if this special contract were not approved?
Well,
let me ask you this first. Is it your understanding that EBON will not locate in the service territory and run its operation in the service territory if the special contract is not approved?
that is what they have indicated in writing, yes.
So all of those economic development benefits that you've described would not materialize?
That is correct.
Can you give some context or explain the constraints that Kentucky Power's service territory generally has as far as attracting industries to locate here?
I can. We don't have a lot of flat land. And the flat land that we do have most typically is constrained by flood issues. And so we have limited access to large sites that would bring large prospects. We do have smaller sites. We do have the benefit, thank goodness, of regional industrial parks where we can locate smaller projects. But we are constrained by terrain. We are constrained by a road system and how we get in and out of southeast Kentucky especially. And like I said, the flat land is floodplain.
So would it be fair to say that not only is it extremely important for Kentucky Power service territory to have economic development, it's also very hard because of the constraints of its territory?
This is a very, very difficult profession to be in Eastern Kentucky.
So based on those constraints that you've just described, would you say EBON and its operation is well suited for the service territory?
It's well suited for the service territory, but it's also well suited for the site. Like I mentioned, the site needs quite a lot of work, and EBON doesn't need a ton of site work in terms of building foundations and building buildings and all of that sort of thing. They can relatively, I don't want to say simply because I've been part of the transmission calls and the engineering calls of how they're going to locate these 250 containers on the property. But they can, more than a traditional manufacturing facility, use that site, and it really is a good use for the site, the best use for the site at this point.
Can you explain what benefits that EBON locating in the service territory, or specifically at this location at the Big Sandy site, would have for Lawrence County specifically?
For Lawrence County specifically, one, for it to be sort of the epicenter of this this growth would be significant. there are massive benefits in terms of getting employees into Lawrence County who are spending their money in Lawrence County every day. Maybe they go to lunch, maybe they buy their groceries, maybe they live there but they buy houses. That's a huge benefit. You know, if you use our model, I think it's $26 million a year that they'll put into the local economy just by trading in that county. And that, you know, that encompasses our service territory, because those of us who live and work in Eastern Kentucky recognize that it is absolutely a regional economy. It will draw from 5, 6 counties around it in order to fill the jobs.
How long has the company been in talks with Ebon about locating in the company's service territory?
Almost exactly 2 years. I think we began at the end of July in '21.
Would you characterize that as a long time to be in talks with a company to locate in the service territory?
It is a very long time to be in talks with a company wanting to locate in the service territory.
So would you say the length of time that the company has been in talks with Ebon to make this project happen and to bring it to fruition shows Ebon's commitment to making this project happen?
I think it shows their commitment to making this project happen, and I think, like I said, the talks with them about locating another component of their business in the service territory shows their commitment to the service territory as well. I don't want to toot our own horn, but I think we've done a very good job in developing a relationship with Ebon, and they are very comfortable with the attributes of the region, with the attributes of the workforce, with the attributes of the site, in order to stick around for 2 years to see it through.
Okay, I'd like to talk about the estimated jobs. So Ebon has represented to the company, as we said here today, that it estimates bringing between 100 and 125 jobs, correct?
Correct.
And I want to talk about the kind of guideline you talked about earlier about estimating the amount of jobs necessary, and I think it was approximately 0.5 jobs per megawatt.
Yes, ma'am.
And so is that based on the approximate amount of people it takes to operate the facility based on its size?
I believe so. I think you're asking me, does 250 megawatts equal 125? Yes.
Yeah, so essentially I think what I'm trying to get at is the more megawatts, the larger the operation, the more people it takes to run.
Correct.
Okay. Even if the jobs that end up being brought and end up working at the Ebon facility are 100 jobs rather than 125, it's still very significant for the company's service territory, correct?
Absolutely.
It's still significant even if it's 50 jobs, correct?
Yes, ma'am.
In fact, is it your understanding under tariff EDR, which could be instructive, that in order to receive the supplemental billing demand discount, the entity only has to bring 5 jobs?
5 jobs, that is correct.
So would you say even 5 jobs is considered meaningful under tariff EDR?
Yes.
But as we sit here today, Ebon has represented that it'll bring 125 jobs, between 100 and 125, correct?
Yes, ma'am.
Do you have any reason to believe that that's not true?
I do not.
Earlier, there was some discussion about the company's ability to maximize the value of the lease with Mr. Samar. And without getting into any of the details of what's actually contained in the lease, I just want to talk generally.
Yes.
Is it your understanding that the company would have offered the same rent amount terms to another customer that was able to locate on the property in its current state?
That is correct.
I'd like to talk about the in-plan model. So is it true that the in-plan model is basically used as an instructive tool?
Yeah, it's IMPLAN, I think, stands for impact planning for, or impact analysis for planning purposes.
And it's not used to specifically predict or verify the economic benefits that a customer will bring?
It's not, it's strictly for planning.
Mr. Samar also asked if there were plans to build offices for 125 employees. Is it your understanding, do you know whether all of the jobs at the Ebon site would require an office to perform?
I don't think so. I think that there will be technicians in the containers that work on the machines. I don't think that all 125 would be sitting at a desk.
Those are all the questions that I have. Thank you.
Ms. Clark? We will take a short recess, and then I'll let you call your last witness. We'll take a recess until, we'll take a 10-minute recess till 4:34, 4:35, and then we'll discuss the rest of the evening.
I'm sorry, that's the Candace, that's mine.
It did.
Okay, we're back on the record in case number 2022-00387. Ms. Glass, would you like to call your next witness?
Yes, the company calls Lara Khan.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Claire Kahn, 1645 Winchester Avenue, Ashland, Kentucky, and I am Manager of Regulatory Services for Kentucky Power.
Okay, and you'll need to pull, I know it's gonna feel weird, but you really have to project when you're inside the cone of it. You have to speak a lot louder than you originally think you, so.
Okay, I don't know how loud I can get.
That's
Okay.
much better. Ms. Glass?
Mr. Garcia Santana will be presenting Ms. Khan.
Thank you, Your Honor. Ms. Khan, did you submit in this case rebuttal testimony consistent of 6 pages of questions and answers and a confidential exhibit?
I did.
And did you also submit answers to discovery questions?
I did.
Were those prepared by you or under your supervision?
Yes.
If you were to be asked the questions, the same questions today, would your answers be substantially the same?
Yes.
Do you have any corrections to your responses or to your testimony or exhibit?
No.
Your Honor, the witness is tended for cross-examination.
Mr. Kurtz?
Thank you, Your Honor. Ms. Khan, you may not be the absolute best witness on this, but at the 83-acre Big Sandy site, if 55 acres are leased to Evon, is there still going to be enough room left to build a combined cycle plant if that's what Kentucky Power wanted to do?
No, I wouldn't be the best witness to answer this. Based on Mr. West's testimony earlier today from Mrs. Clark, I believe they answered that and said that there would be.
Was that as to a combustion turbine or as to a combined cycle?
I'm sorry, I don't remember.
We'll ask that in a post-hearing data request, if that's okay, Your Honor. Will you turn to Exhibit 1 of your rebuttal?
Yes.
Your Honor, if I am correct, that exhibit is confidential? Is that the one that you're referring to?
I don't think, I think, I am going to ask about confidential, but I don't think number 1 is. It's public.
There's a public version and a confidential version.
Oh, understood, Your Honor. Thank you.
I'm there, Mr. Kurtz.
Oh, okay. The public version.
Okay.
On line 2, DALMP, that's day ahead LMP locational, that's the day ahead energy price?
Correct, however, the company has set that rate at our fuel adjustment clause and base fuel rates. So
I'm sorry,
I think
say
it's
that
a bit
again. What?
the company, that line is actually set on based on the revenues tab to what our fuel adjustment clause rate and base fuel rate is. So it's a bit misleading to say day ahead LMP there.
Well, that's my question. What you've assumed in your marginal cost study is that the company will go ahead and purchase 2 billion kilowatt hours of power from the PJM market to serve Ebon, correct?
Correct.
In years 2 through 10, correct?
Correct.
Okay, and that Ebon will essentially pay the full market price so that the cost and the revenues completely offset.
That's correct for our assumptions in this, and this was really just used as this wasn't a decision as to whether the company would contract with Ebon. This was an informational purpose document for whether the discounts were adequate for the economic development discounts that UBON, or benefits that UBON would bring. So yes, it was an assumption that we made here.
So you assumed that Ebon the company would purchase 2 billion kilowatt hours from PJM Energy, and that Ebon would pay for it dollar for dollar at $43.05 per megawatt hour.
Correct.
Okay, that's not what's going to happen in reality, is it?
No, I believe, or AGKIUC witnessed, Barron goes into this some, that it's going to be the fuel adjustment cost specifically is how much fuel it costs for our units to run, how much it costs for us to purchase energy on the market, and then how much offset there is for what we sold on the market.
So in reality, in reality, the 2 million megawatt hours or 2 billion kilowatt hours of market purchases will be flowed through to all of your customers, and that EBON will pay its proportionate share, but everybody else will pay the remainder.
So I would put it that they'll pay it at tariff rates back, which I believe is what you're saying, which is an average mechanism. So if we have increased costs, the fact is simply what we need to recover during the month divided by the sales. So if we have increased to that total cost to be recovered, that could increase the fact for everybody, but the sales as the denominator growing as well could actually make it a decrease for some of those months.
So-
It could go either way.
So when you buy 2 billion kilowatt hours per year to serve EBON, everybody will have a greater percent of their bill at market pricing versus the cost of fuel from Big Sandy and Mitchell, correct?
Correct.
And we saw what happened when you were overly reliant on market purchases and the fuel adjustment in 2022, correct?
I guess I'd need to understand what the question is.
So the fuel adjustment went way up because the company was so reliant on market purchases.
So I think the fuel cost for everybody went significantly up, so I think we can agree on that.
And by adding 2 billion kilowatt hours of extra market purchases to serve EBON, which they will pay a share of, but other ratepayers will pay more, that makes the bill that customers get, a greater percentage of it will be market-based versus cost-based.
So I wouldn't agree to the extent that I said, because the denominator could actually, even if there's an increase in the total per month, the denominator growing as well could cause a reduction to other customers. But yes, because of the reliance on the market, there is more risk attributable there. But that being said, it could go either way.
Okay, and again, Mr. Barron adjusted for this fact, but your analysis assumes that EBON will essentially pay 100% of the market purchases, but that won't really happen in reality.
Yes, we believe that this is a reasonable assumption. I would also note that Mr. Barron's doesn't acknowledge the possibility for it to go either way. It's simply always going to be more.
Well, I get, do you know what the generation cost at Mitchell is?
No, I don't.
So if market prices are lower than, it can only go one way. If market prices if you're relying on the market, which you have to be because you don't have enough energy to serve existing customers, you're relying on the market. Let me stop, let me restate that question. As a result of this contract, customers will have greater risk of market exposure, correct?
Correct.
So it kind of balances out whether that risk of extra market exposure for your regular ratepayers is offset by the promise of these jobs. That's kind of what it boils down to.
Yes, but I wasn't a part of the contract negotiations. That's not what my role in this was.
Thank you, Chairman. That's all my questions.
Oh, I just thought you were being polite, Mr. President. Mr. West, would you like to?
I don't have any questions for this witness.
I don't have any questions.
Oh, yeah. Sure.
Have you heard the questions that I've asked today to Mr. West particularly?
I have. I think I went out of the room maybe, but I think I was pretty much here.
I don't blame you.
You work for Kentucky Power, right?
I do.
Okay. And you do a lot of rates and regulatory work, is that right?
So I would be the lead on the environmental surcharge, and then I do the fuel adjustment clause as well. I also do a lot of the annual rider updates, but in terms of cost of service, that's a AEPSC.
Okay. You're generally aware of tariff PPA?
I am.
Okay. Do you help with processing those filings?
I do.
Okay. And you have an appreciation for the cost components of tariff PPA generally?
Generally, yes.
Okay. And do you see the bills, the allocated bills from AEPSC to Kentucky Power for PPA cost components, or do you just see the final amounts?
I do not see the bills. I see an accounting spreadsheet that would come to me that would likely have components of the bill
Okay.
carried forward.
Okay. Are you generally aware of PJM LSE owed expenses as
I
a
am.
line item? You are?
Yes.
Has that amount, since you've been to Kentucky Power, increased or decreased or stayed the same?
I think it has increased annually since I've been here, and we actually provided in response to commission staff certs that I'll just get there. Might take me a minute.
And when you all say third set, these are the responses that were filed 2 weeks ago, right? July 5th?
I think those were the dates, that was when they were dated to us.
I'm sorry, July 7th, July
That sounds-
13th.
That sounds right.
Okay.
And I don't have the attachment, so I didn't make a very good job making my own book. But in response to staff 3-2, I believe we provided an attachment that shows what our expenses for transmission nets costs have increased year over year. And an average yearly increase for the past 5 years has been 11.2%.
Okay. That's more than twice the 5%.
It is.
Can you explain to me the response at the bottom of that? Sort of the mitigating factor that you try to explain around what is, quote, escalation to costs?
Yeah, so I think I'm just saying that because we're acknowledging, or I acknowledged in what I provided, that 5%, that we also didn't do any kind of escalations to the revenue side, and as staff noted, I believe in one of the first set of discoveries, there would also be an increase to what the customer has to pay in PPA. I don't believe it would be an exact 12% or 11% or whatever. It might not be an exact approximate, but they would increase directionally the same. So because I did not provide for revenues at an escalation as well, it was an incomplete picture.
Okay. What is the 5% estimated assumption based on?
It's just a number we chose based on the subject matters experts that I had, that it was reasonable. We've seen as low as a 2.2% increase, which is again, on the attachment that I don't have. But it was just what we assumed as a reasonable measure for here. There's really nothing more to that.
Okay, so you're talking about the Kentucky Power Company R KPSC 3.2 attachment 1?
I'm sorry, could you repeat that?
Yeah, you're talking about the attachment 1? The attachment to that request is the attachment you're saying you don't have?
Yeah, I'm sorry, I didn't print a copy for myself.
Okay, that's okay. So, but you've seen it where, let me just tell you, you're talking about the percentage change to prior year, that 2.2% reference. Is that what you were talking about?
11.2. An average for the past 5 years has been an 11.2 average increase year over year.
You mentioned though that 1 year is only 2.2%.
Oh, yeah, sorry, that's shown on there. I don't remember which year it was in though.
It's the 2019 PTRR.
Would you mind if I provided the spreadsheet
That'd be great.
via my iPad? Okay.
Thank you, Ms. Foss.
Do you see that the 2022 is the 2019 PTRR?
Yes.
Okay. Do you know why that was only 2.2% that year?
No, I don't.
When did you arrive at Kentucky Power?
I started June of 2018.
June when?
2018.
Okay. Do you remember, do you remember, I'm trying to think. So, in the 2017 rate case, Kentucky Power was permitted to track the increment and decrement of 80% of base tariff PPA expenses. Do you remember that?
I do. I read the order.
Okay.
After I started.
Okay, great. And then, do you remember in the subsequent year, there was actually a FERC case that reduced the ROE and that subsequently was the 2019 cost, or I guess technically the 2018 costs weren't near as much as was anticipated because of that?
I'm not familiar with it. I'm sorry.
Oh, you
I
don't-
wouldn't have been doing any of this stuff at that
Okay.
time.
How about, do you remember that Kentucky Power explicitly requested not to pass back the savings from that? Do you remember that case at all?
So I don't think it was a case, was it? Was it just our traditional PPA filing that you referred to?
It may have been, that's right.
Okay, yeah.
But do you remember that specifically, that you were asking to actually hold on to the savings for an additional year, even though you just requested and been approved the ability to track? Do you remember that?
I'll take your
That's okay.
word.
But that was a one-off situation while that year was 2.2%. Would you
Okay.
agree?
Yes.
Okay. And actually, that 2.2% being a one-off issue significantly brings down the average. Would you agree with that?
Yes.
Okay. What is it about transmission expense? Just help me out. Why was I know you said you just picked a number that seemed reasonable. Was it based on anything that is allocated to you all regarding transmission expense?
No, not to my knowledge.
What do you think a reason, if you were doing it again today with the benefit, if we'll call it that, of the last 8 months of this case, what do you think an appropriate escalation factor for transmission expenses are?
I would probably say 10 to 15%, so long as you also took into consideration that the PPA revenues would also need to increase.
Okay. And have you done that with the 10 to 15%, but with the escalation of the other revenues?
Back of the hand napkin I did, and directionally it was still the same. On my analysis, directionally came out to the same.
Directionally what? Did it reduce the economic benefit of the margins produced under this agreement?
I don't remember the end result. I just remember that I was still a net positive. I don't know what the exact, if there was a decrease and by what extent there was a decrease.
Okay.
I was looking to make sure that it was still a net positive as my ultimate goal.
Okay, but you don't remember being a net positive compared to the actual whatever the current analysis is for you all, you
Yes.
don't remember if it was higher or lower?
Correct. I don't remember what that came out to.
What is your all's current analysis of what you believe to be the best, the best version of the economic analysis of this contract on the remaining system?
I'm sorry, I don't understand the
Yeah,
question.
I was told by Mr. West today that you all have updated the original analysis 3 times now.
So yes, the first time was we provided the marginal cost on a cumulative basis, so it was just like one column.
Okay.
So the second time that we provided, it extended to provide 10 years, so it broke it up by year. And then the last time was in response to Mr. Barron's testimony. So it's fundamentally stayed pretty much the same. I wouldn't say that it's significantly different between the variants.
Okay, and so what about the study that Mr. West indicated that you all did for commission staff regarding the incremental cost of capacity?
I'm not sure what is being referred to there.
The 25 megawatt, the cost of the
I'm
additional 25 megawatts capacity.
So that was in response to staff 1.9. They asked for generation costs, capacity costs to be considered, so we did the exact same thing. we provided both scenarios with and without, and the one with was based on net cone at $220 per megawatt day.
Okay. So, but that's not the one you're depending on in furtherance of the application, is that right?
No, it's as Mr. West has already talked about today, we do support that there is no generation capacity costs associated with this customer because we don't typically assign capacity costs on individual customer basis. We're still, I believe that capacity costs still remain less than what they were under the Rockport UPA. But we did provide it and believe if that is informative to the commission, that it's available to be used for their review.
But you provided a marginal cost study that allocated specifically to this customer energy costs, but you don't, on an ordinary basis, ascribe a specific energy cost to customers. You don't do a stacking methodology with a stacking of customers and say that Bob's Muffler Shop gets the first cheapest unit and then everybody else pays the more expensive unit as we go up, right?
No.
Okay, so why would it make sense to include the marginal cost of energy in the marginal cost analysis, but not the marginal cost of capacity?
I relied on the subject matter experts to provide that input, and that was their opinion based on what I've already mentioned.
Okay. And even assuming you already had the capacity, there's an avoided cost of that capacity, right? Like if it doesn't go to serve one customer, it would go to serve other customers or be used to make off-system sales. Would you agree?
I would.
So the tariff PPA, oh no, sorry, scratch that. The cost allocated to you under tariff PPA changes any given year. Do you get the tariff PPA inputs after the allocation is done and AEPSC is exclusively the one dealing with the allocations? Or do you see the 1CP, like LSC Oak cost, I believe, go to AEPSC on a 1CP basis and then they reallocate it on a 12CP basis? Do you see it at the costs at both points?
I do not. I know that we file I believe the 12 CP with the commission annually, and I do see that.
Yeah, but you don't have anything, so like it may be 5.6% your all's allocation based on a 12 CP. Are you just given that by AEPSC, or does anybody at Kentucky Power that you're aware of work to figure out if that's the appropriate allocation?
From what I've seen from that spreadsheet, it's a pretty simple inputs and then our peak divided by the total. So
Okay.
I look at it on that front, but nothing more than that I'm aware of.
Okay, great. And then tariff PPA, you're generally familiar with it. How is it allocated to customers, to different customer classes?
So in rate cases, we provide for the CP ratio. That's updated in the rate base, and then we update it annually depending on the customer. They're mostly based on KWH rates. I believe it's IGS and LGS that also has a demand rate.
Okay, but like, so you have the residential class. Let's just take the residential class and IGS for a second. Is the split between residential and commercial customers for tariff PPA, is the total allocated to those individual classes or groups like residential, non-residential, is that done on a revenue basis or kilowatt hour basis?
I believe it's on a kilowatt hour basis.
Because the decommissioning rider is first allocated, I believe, between residential and non-residential on a revenue basis, and then is allocated within those individual classes on a kilowatt hour basis. Do you know whether tariff PPA is?
I don't think that the decommissioning rider is further broken down by KWH basis.
It's not paid by KWH? Oh, it's based on the factor, right?
Yeah.
Okay, so, but I just want to talk about the first part.
Okay.
Do you know if tariff PPA is broken out that way amongst residential and non-residential customers, where it's first allocated based off of revenues?
I don't believe it is.
Okay, that's what I wanted to know.
All right, so we know tariff PPA, we know FAC. Are there any other tariffs or riders that the company has that an increase, or assuming that, let's just say, with the addendum that the company plans on filing regarding the clawback provision, that would be affected or impacted uniquely by this contract?
I wouldn't say uniquely. To your point with the decommissioning rider and the ES, their percent of revenues, so the more revenues we have, which EBON would bring, they would reduce those rates
They would reduce those rates, but they would be allocated,
based on
On
their
a-
customer classes,
okay,
based on residential and all other.
yeah, based on revenues.
Yes.
First, yeah, okay. Do you agree that this should be a present, do you think this should be a present value analysis or a net present value analysis?
I think what we used is reasonable, but I'm not going to say that there aren't other reasonable approaches.
Okay.
Sorry.
No, that's okay. I really asked about the bankable, really curious about the bankable dollars.
Okay, I didn't have any participation in the,
Well, I guess what I'm really trying to say is, and Ms. Bush, you tell me if I'm going into confidential session or not, but insofar as, I mean, the concept is public, right?
The fact that the floor price mechanism and the floor price exists is public, but if you want to get into how that works, I would say it's confidential.
Okay. Here's what I really want to get across. There's a real time value of money component when it comes to customer dollars and utility investments. Would you agree?
yes,
Okay. And $1 in year one of a contract, like if you're given a discount for $1 in year one of a contract, that is worth more than $1 in year 10 of the discount, all else being equal, right?
right.
Okay. Thank you, Ms. Khan. Mr. Garcia Santana, do you have any redirect of the witness?
Just a few, Your Honor. Let me pick up with the very point that you were just asked about, Ms. Khan. Regarding a time value of money or next present value calculation, would that require making assumptions about what the applicable change rates would be?
It would, I believe my understanding of those is that it's a variable relying on several other variables to an analysis that already has a lot of assumptions within it.
Okay, and just to make sure, the analysis that you performed to calculate the marginal cost of serving this particular customer under the special contract, that required for you to make some assumptions in order to be able to make that calculation, correct?
It did. I wouldn't say necessarily, the assumptions were often provided to me by subject matter experts. There's a lot of tabs within that spreadsheet, and I'm certainly not an expert within all of them.
Certainly. But for the purposes of what, well, let me ask you this. What was the purpose of you conducting that calculation?
It was simply to be informational. As far as Mr. West was concerned, when he came to me on that, he was presented with two options available to him, and it was whether EBON would go under standard tariff rates for IGS, which would consider adding 250 megawatts, or whether EBON should be considered under a special contract, one, to secure the load, but also to require that they interrupt. So ultimately, this just informed informationally whether the discounts that were ultimately provided within the special contract were appropriate.
Okay, and for those purposes, are the use of the assumptions that you received from others in order to conduct your marginal cost analysis, are they reasonable for this purpose?
Yes, I believe so. They're going to directionally show what we can expect. They're reasonable, and I think we can assume that they are reasonable for the future, as shown with the fuel costs that have been discussed today several times. Those really escalated in 2022 for various reasons. So I think this analysis was reasonable and was a reasonable expectation for the future as well.
And now that you're mentioning fuel and energy costs, I think that one of the measures that you were asked about were locational marginal pricing, LMPs, is that right?
Correct.
Have you had occasion to check recently in what direction those have moved, like, for example, compared to the assumptions that Mr. Barron did in his analysis?
Yes, so I looked at the month of June, and I believe that was in the high 2s. And I think for July, it was in the low 3s.
Thank you, Honor. That's the extent of the redirect.
Thank you. Are there any other questions for this witness? Vice Chair? Thank you very much.
Thank you.
Mr. Garcia Santana or Ms. Glass, do you all have anything else? Any other witnesses or would like to recall anyone?
No, Your Honor.
Okay, all right, thank you. Let's take just not a break. Let's talk just for a second before we move on. It is almost 5:15. We have both of the joint interveners, both of the joint interveners witnesses. We also have Mr. Barron. My anticipation is if we expect to go into the night, that we take a 30-minute break at 6 o'clock, that we'll know in probably the next 15 or 20 minutes whether we should take a break at 6 o'clock for dinner or push on. So we'll take our first witness, maybe our first two witnesses, and then probably at about 6:15, I'll make a indication whether we should plan to take a break a little after 6 for dinner, probably 30 minutes, come back, and then continue with the hearing, or we'll probably know within the next 30 minutes whether or not. This is always the time where the rubber meets the road as to how many questions people really have. But anyways, so I just want to say that to see if anybody has any concerns or questions. Okay. And you all have a room here, correct? You all have a breakout room?
I'm not aware.
Okay, you do now. It's conference room 1.
Thank you, Honor.
And Mr. Barron and Mr. Kurtz, if you all need a space, you all can have our filing room, our old filing room.
We have a room.
Okay, you all have a room in CR.
Just this conference room right here.
Great. So then I'll turn that you all can have this room if you all need a chance to place to sit or put your things if we take a longer break. So, okay. Any other questions? All right. Since you wanted to go first for your cross-examination, Mr. Kurtz. Oh, actually, before we move on, I don't think Mr. Kurtz moved to introduce KIUC Exhibit 6. I have a note here that you did not. Would you like to at this point?
I would. Thank you, Your Honor.
Ms. Glass, Mr. Garcia Santana, do you have any objection to the introduction of KIUC 6?
No.
Okay. All right. So we now have KIUC 1 through 5 with, again, KIUC 5-4 being confidential. All right, Mr. Kurtz, would you like to call your witness?
Thank you, Your Honor. AG KIUC call Mr. Barron.
All right, Mr. Barron, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat and state your name and address for the record. Oh, yeah, sorry. State your name and address for the record, please.
My hearing is not great, especially with this. I apologize. My name is Stephen Barron. My business address is J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia 30075.
Mr. Kurtz?
Thank you, Your Honor. Mr. Barron, do you have in front of you a document, direct testimony and exhibits of Stephen J. Barron?
I apologize, you're going to need to
Okay,
speak
do
up.
you have a document in front of you, your direct testimony?
Yes,
Was it prepared by you?
yes, it was.
Do you have any corrections or additions?
Not that I'm aware of, no.
If I were to ask you the same questions, would your answers be the same?
Yes.
Your Honor, I tender the witness for cross.
Counsel, do you have any questions for this witness?
We do not, thank you.
So I'll ask Mr. Garcia Santana.
We don't have any questions, but we'd like to request the opportunity if any questions arise based on other cross-examination.
We'll always come back around. That'd be
Thank you.
fine.
No.
I just want clarification, I think is my only question, Mr. Barron. The 12% that you used for the 6 years, where did you get that information for the escalation of transmission expenses?
The data came from it actually, I was able to use it from the Liberty case where we compiled AEP transmission date, revenue requirement data, and then allocated down to Kentucky Power. So, but it's all based on the AEP transmission filings at the FERC under the OATT.
Do you do work in Texas?
I'm sorry?
Do you do work in Texas?
My firm does, but I haven't testified, worked there in many years, probably 20 or so.
All right. Ms. Glass?
Are you asking me if I have
If you have
additional
any questions, yeah, I'm sorry.
No, Your Honor, thank you.
I have one redirect. Do you happen to know if that 2.2% transmission increase, that anomaly, was a result of the Tax Cuts and Jobs Act of 2017 that lowered the corporate income tax rate?
I'm aware that the FERC required a revenue requirement reduction to reflect the Tax Cut and Jobs Act impact.
Do you think the 2.2% anomaly was a result of that tax change?
I would consider that an anomaly, yes. And
Thank you, Chairman. No more questions.
it's not,
Ms.
well,
Glass?
who knows whether it's likely to occur again or not.
Ms. Glass?
No
Anything else?
questions.
All right. Any additional questions for Mr. Barron? Any objection to excusing it?
All right. Thank you, Mr. Barron.
Thank you.
It's better than the alternative.
Yeah, well, it was good to talk.
Mr. West, Mr. Kurtz, any additional witnesses from you all?
No, sir.
Anything else for your case?
No, sir.
Smar, will you be introducing your first witness?
Yes.
I'll give you just a second. And you can call your first witness when you'd like.
Thank you, Your Honor. Joint interveners would like to call Stacy Sherwood.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please state your name and business address for the record.
My name is Stacy Sherwood, and my business address is 10298 Route 116 in Heinsberg, Vermont, 05461.
Mr. Smar?
Good afternoon, Ms. Sherwood. Are you the same Stacy Sherwood who caused to be filed testimony in this case in February of this year?
Yes.
Did you also cause to be filed a corrected version of your testimony in March of this year pursuant to a motion that joint interveners made for leave to file that testimony?
Yes, I did.
Did you also cause to be filed responses to data requests in this case?
Yes.
If I were to ask you the same questions today, would, other than the corrected version of your testimony, would the corrections made in your corrected version of your testimony, would your answers to the questions both in the testimony and the data requests be substantially the same?
Yes, I would.
Do you have any other corrections that you would like to make to your testimony or data request responses today?
No, I do not.
Thank you. Your Honor, the witness is available for cross.
Mr. Kurtz, Mr. West?
No questions.
No questions.
No questions.
No questions.
No.
I have no questions for I do appreciate you spending in our economy here in Kentucky, coming here. But like I say, it's better than the alternative and you being on the stand for 5 hours, I'm
Yes,
sure.
Georgetown is lovely.
Mr. Smart, anything else?
Oh, we have Ms. Hoteling, who's,
Great. Anything
Oh.
from Ms. Sherwood?
nothing from Ms. Sherwood.
Thank you, Ms. Sherwood. Be excused. Judge Clark, next witness.
Yes, Your Honor. Joint interveners call Ms. Chelsea Hoteling.
Ms. Hoteling? Can you hear me? Can you hear me, Ms. Hoteling? We cannot.
You're on mute.
I think it may be on our end, though. All right, give it another try. No. All right, what we'll do is, we'll be in a short recess until, until I call us back in. And if Ms. Hoteling, you can stick around, we will check back and check in the back and see if we can hear her back there. So, all right, we'll be in a short recess. back on the record. Ms. Hoteling, can you hear me? All right.
Is there an option to switch to phone? Could she call in phone audio?
Yeah, Ms. Hoteling, do you mind to try, you'll need to mute your microphone and then try to change your audio, and it should give you a call-in option. If you could try to do that real fast. Try it one more time. No, we cannot. Very frustrating. All right.
Speaker anywhere? Where's the speaker?
No, it's the bigger speaker. It's not coming through. Yeah, hold on one second.
No questions.
Yeah, I was gonna
We'll stipulate.
clarify. Do you all have
We were
questions
just
for Ms.
discussing
Hoteling?
the same. We have no questions, we'll stipulate.
Do you all have questions for Ms. Hoteling?
No.
Sure. Okay.
No, oops, we
It
lost.
is.
Okay. So, Mr. Smar, would you like to make a motion or move that Ms. Hoteling be excused from the hearing in this case?
Sure, Your Honor, we would so move.
Okay, and that her testimony be adopted as previously filed in the record?
Yes, Your
Okay. Is there any objection to that?
No.
Ms. Glass?
No.
Okay. All right, thank you very much, Ms. Hoteling. Sorry that you had to stick with us, we've had these technical difficulties. This is the first time this has actually happened in 3.5 years, so, thank you very much. In the event, the unlikely event, Mr. Smart, that Ms. Hoteling was planning on amending or providing an errata to her testimony, I just asked that, from the stand, I'd ask that you just follow up post-hearing and do so in writing. Okay, is there anything else from the joint interveners?
Nothing.
Anything else, Ms. Glass?
No, Your Honor, just a matter of briefing. I hope I'm not jumping the gun, but that's about it.
Nope. We can have post-hearing data requests and a procedural schedule entered by tomorrow. A post-hearing procedural schedule entered by tomorrow and post-hearing data request issued by tomorrow. Given the questions that you've heard today, well, let me ask, Mr. Kurtz, so you have 2 questions, is that right, Mr. Smar, that you'd like to ask as post-hearing data request?
That's correct, Your Honor.
Okay, you've already got them drafted, because I could tell you were reading from the questions. Mr. Kurtz, you had 1 or 2, is that right?
Just one.
Okay, and I think we have less than half a dozen.
That's correct.
Yeah, so, does anybody have an objection to, we're seeking those data requests by tomorrow, end of day?
That's fine.
No, that's fine.
Okay, so data request and a procedural schedule can be issued by tomorrow. Is 7 days sufficient, given the questions that you've heard today, to respond to those?
Yes, Your Honor, thank you.
Okay. I'm just gonna take a wild guess. Would you all like to brief this case?
Yes, we would.
Okay, so given the statutory date that we have and the sort of situation we have with the hearing and everything else, and the change of 2 changes, I think, of procedural schedule that we had, we have a very short time frame for this, for the statutory date, given that it was a tendered tariff.
Your Honor, if I may, I think we're past the suspension date already.
The suspension date, I'm at the statutory date. You think you all were past the statutory date as well?
Well, I'm afraid to ask.
So it's my understanding that the statutory date is August the 28th in this case.
Okay. For a special contract.
I don't, assuming worst case scenario that 278-190 applies and the 10-month application applies.
Okay, thank you, Your Honor. I'll
I don't know that
accept
it does, I'm
I'll-
just,
Yeah.
worst case scenario here is what I'm not gonna accidentally let something,
That's
go into
completely
effect.
understandable.
Yeah.
Thank you.
So assuming that is the case, And given that we would actually need time to read briefs and issue, come to a decision and issue an order in a reasonable amount of time. At this point, my request would be that initial post-hearing briefs, simultaneous briefs, be filed August the 4th, and that we do reply briefs August the 11th. I am willing, if it's, you all are interested, I'm willing to extend that August the 4th deadline if you would prefer to keep the August 11th there and have less time to respond, but more time to do your initial brief. I'll leave that up to you. But it needs to be submitted by August 12th, or there's no way we can read the testimony, read the entire record, come up with a decision, and draft and issue an order by August the 28th.
Yeah, so the company would request to take more time on the front for the initial brief, and we can still file the reply. The company would suggest perhaps filing first briefs by August 7th or 8th.
Agree. We agree.
Yes.
Okay, great. So let me check my calendar here to make sure that the 7th or the 8th isn't some. Everybody fine with initial briefs, simultaneous initial briefs by end of day on the 8th, and reply briefs by end of the day on Friday, August 11th?
Yes, sir.
Okay, so we'll enter a procedural schedule to that effect tomorrow, and the case will be submitted 12:01 on the 12th. The post-hearing procedural schedule will indicate this much, but I feel like it's important to go on the record as well. We will only entertain reply briefs that address issues raised in other parties' initial briefs. That if you raise something for the first time in a reply brief, don't waste your ink, I guess is what I'm really trying to say, or your finger typing time, whatever it is these days. That we just won't take it, we don't have the time to take it into consideration. All right. Is there anything else? Okay. We will timely issue an order on the 4 pending petitions for confidentiality. And if there's nothing else, this hearing is adjourned. Your Honor.
I was thinking I was giving you guys more time to actually review the testimony. You're welcome to. You're welcome. Thank you.
Good, thank you. Good to meet you both. Thank you.
Just a moment. Peppermint's on. Will make you more awake than coffee while you're driving.
I didn't know that. I did know that peppermint is also a, well, chewing, just the act of chewing, and I think peppermint too will deter food cravings.
Oh, really? I apparently need that. Do you think we're still on the record?
Yeah, I'm confused, I
With
don't
the-
know why
Oh.
it's still
With the
there.
website?
Yeah.
The thing that I'm not saying anything.
Oh, maybe they're testing their system.
There is a significant echo.
Got way too much stuff. I'm really spread out.